to hear. It's a presidential reference after all. So we are already telecasting it, and I think a public notice has been put outside with the link. There are two links. You can go direct, you can go through the Supreme Court website, or you can go YouTube. The link is there. So your application, before your application was filed, this decision was taken.
Thanks a lot, my lord.
You can see this is live. This is the LCD. This is live telecast.
Okay.
Yes, this is live streaming.
Thank you, my lord. Thank you, my lord.
No, you don't need to thank us.
Because this is a case of historical importance.
No. That's one thing we don't want to do. First of all, we want to treat it as a presidential reference. Can you take, I don't know, whether you will start or we'll request the Attorney General.
Attorney General will start because the reference is by the President.
Yes. So first question arises is, presidential reference is still here before us. It was not withdrawn. So I presume presidential reference you still want to pursue.
My lord, I have no contrary instructions, so yes.
Oh, so he wants to continue the presidential reference. So can we read the presidential reference?
So before we proceed, I will request your lordship to read an order.
So before we read, let's start.
An order has been passed for summing of certain record. An order was passed by this honorable court while hearing the presidential reference. When my lord, Mr. Justice Chaudhary was the Chief Justice, an order was passed that certain record is not over here. And those documents are very important for the purpose of deciding this presidential reference. If your lordship will allow me, I'll read that order which was passed.
We will certainly allow you, but at the appropriate time. Let's start with, because none of us were judges when the presidential reference was filed, nor any of us had heard the presidential reference at any stage, nor there is any judge in the Supreme Court who's heard it. So you may even wonder on the constitution of this bench. It was placed before the committee as, let's not keep speculating on everything. This Chief Justice has relinquished powers and now matters are decided by the committee. Just 2 seconds, just bear with us. What we did was, one senior member did not want to be part of the bench. 2 others was some way or the other related. It was felt maybe they should not be. So just want to allay that. And since the last time it was heard was 9 members, so we tried to do the same because, sparing a lot of judges also takes time. So now if we will start with the presidential reference, and then we will go through all relevant orders. So Attorney General, can we request you to read, since it's your presidential reference, if you can read the presidential reference?
Sir, I'd just like to point out.
We will go, don't worry.
I just want to point, a tribunal was formed, headed by Justice Shafiur Rahman. And
Farooq Saab.
Okay, sir.
Don't mind, but let him start. Okay. So actually, to be honest, I've not read it.
Okay, sir. Thank you.
So let's read it.
My lord, this reference comprises of 15 pages.
No, not the facts. What does the President of Pakistan want us to do?
My lord, if my lords may kindly turn to order dated 21st of April 2011, and order records the questions which were referred.
So before that, in the presidential reference, it is under which article of the Constitution?
186.
Can you read 186? We do one thing at a time. It's reproduced, I think, in the first page of the presidential reference.
Clause 1. If at any time the President considers that it is desirable to obtain the opinion of the Supreme Court on any question of law which he considers of public importance, he may refer the question to the Supreme Court for consideration. 2. The Supreme Court shall consider a question so referred and report its opinion on the question to the President.
Okay. Now this is an extraordinary power vesting in the President. And which President had filed this reference?
Sir, President Asif Ali Zardari.
Okay.
On the advice of the federal government, the cabinet.
And what was his tenure in office till?
I believe it was 2008 through 2013.
And after that, how many presidents have come?
2, my lord.
And none withdrew it.
None of them.
So it's still on our docket.
That's right, Ma'am. It's presidential reference number 1 of 2011.
I must regret on behalf of the Supreme Court that it was not listed earlier, because we have a policy now of first in, first out, unless there is some urgency in a particular case. Okay, so would you like to refer to the presidential reference or the order now?
My Lord, I'd like to refer to the order because that order then captures the questions.
Okay, which order is that?
It's 21st April 2011, 21/4/2011.
21 April.
Isn't there a question in the reference itself?
My Lord, the questions were in the reference also, but
why don't we go to the question of law that was, Mr. Attorney General?
My Lord.
Could we just refer to the question of law raised in the original reference?
My Lord. My Lords, if my Lord may kindly turn to page 16 of the reference.
No, it finishes at 15.
15. There is no question.
It finishes at 15. 16 is a summary of the Prime Minister.
These were placed subsequently. There was an order dated 13, 14 and 18 of, there were orders, several orders of 13, 14 and 18 April 2021. 2011 and on 21/4.
Why you read the reference?
I can
read the title of the reference that itself sums up the question, but after a reference ka title
reference by the President of the Islamic Republic of Pakistan under Article 186 of the Constitution of the Islamic Republic of Pakistan to revisit the case of Zulfikar Ali Bhutto, reported as PLD 1979, Supreme Court,
original file
53, 38.
File separately some questions, because in the reference the questions are not reflecting in any heading.
My Lord, if your Lordship will allow me, it's a reported matter. The order of this Honourable Court where the questions were framed.
That was
like
the
a leave
questions
granting
framed
order.
by the court.
Yes, ma'am, but
They
the
are
court.
asking what about the questions which you framed in your reference for the opinion of this court?
That is in the reference.
My Lord,
But this Honourable Court also framed the questions.
Which were framed in the
This Honourable Court also framed the question, and it is a reported
I
matter.
think, Mr. Attorney General, why don't we just read the entire reference?
my Lord.
And if there are sort of irrelevant or just factual things, we'll skip those.
Well, what happened was that after
let's now
the reference was filed, the questions were subsequently forwarded. I'll skip the language of Article 186 from page 1 and then I'll read. After the restoration of judiciary by the present democratic government, all the institutions of the state are adhering to the constitution and constitutional scheme of trichotomy of power. The judiciary in Pakistan is independent and is playing a proactive role in the cases of public importance. However, some important questions of law remain unanswered, and one amongst them is in waiting since long. This is the case of Zulfikar Ali Bhutto, reported as PLD 1979, Supreme Court, page 38, decided in Criminal Appeals number 11, 12 and 13 of 1978, who is the founder of the Constitution of Pakistan, first elected Prime Minister of the country, leader of the Third World, Prime Minister of Non-Aligned Movement, founder of the Islamic Bloc, who took the initiative of introducing nuclear technology in the Muslim world. He was convener of the first Islamic Summit in Pakistan, which attracted unparalleled participation of leaders of the Muslim Ummah. Facts. In pursuance of wide-range conspiracy, Shaheed Zulfiqar Ali Bhutto was challened by the Federal Investigation Agency maliciously to face trial for offences under Section 120B, 302, read with Section 109, and 301, and Section 307, read with Section 109 PPC. The trial was conducted by the Lahore High Court in a highly objectionable manner, and he was judicially murdered. I, as the President of the Islamic Republic of Pakistan, in order to uphold the dignity of the court, supremacy of the Constitution and law, feel constrained to refer a few questions of law which are of paramount public importance and remain yet to be finally determined and answered by the Supreme Court of Pakistan. 1. The law of approver and criminal conspiracies admittedly against the injunctions of Islam, the Holy Prophet, peace be upon him, on the occasion of Hijjatul Wada, pronounced, beware, every culprit is responsible for offense committed by him. Beware, the father is not responsible for the offense committed by his son, nor son is answerable for the offense committed by his father. Admittedly, absence of the accused from the scene of occurrence could not at all constitute personal liability. 2. Earlier, no accused had been convicted and sentenced to death solely on the testimony of an approver. The Honorable Supreme Court of Pakistan has again disapproved the testimony of an approver in the case of Mian Muhammad Nawaz Sharif versus State, PLD 2009, Supreme Court 814, and the law continues to be volatile. The testimony of the approver fails to satisfy both the tests in that he is neither reliable nor his testimony is corroborated in material particulars. 3. Intricate questions of public importance are involved in the matter. None is above accountability in Islam, and more so a qazi. Determination of the question of accountability, or at least a correction of error, amounts to introspective accountability. The democratic system of a country is dependent on the functioning of political parties. Leaders of political parties are repository of public trust and confidence. Their iconic image is an inspirational and motivational force for the followers. In the case of Shaheed Zulfikar Ali Bhutto, this goes without saying that he was the leader who inspired generations. His charismatic leadership remains a role model for the toiling millions of Pakistan and the Third World, and his appeal for downtrodden is transcending through an annals of history. His totally illegal death sentence and his execution at the hand of tyrant dictators with the help of hand-picked judges is a black spot on the democratic face of Pakistan. 4. Whether the Supreme Court was acting within four corners of law while deciding the appeal by a bench, which was not duly constituted after the absence of two honourable members, namely Mr. Justice Wahiduddin Ahmed, who was shown sick, and the bench chose to proceed in his absence, notwithstanding the fact that he was desirous to join the proceedings, and Mr. Justice Kaisar Khan retired during proceedings. The Honourable Court was legally and morally duty-bound to fill the vacancies. 5. In the case in hand, bias in the minds of judges was floating on the face of the record. A bias in the mind of judge results in vitiation of the proceedings. In the celebrated judgment reported as Asif Ali Zardari and another versus the state, PLD 2001, Supreme Court 568, while dilating upon bias, the Honourable Apex Court held as follows, as under C. A judge may have a personal bias towards a party owing to relationship and the like, or he may be personally hostile to a party as a result of events happening either before or during the trial. Whenever there is any allegation of personal bias, the question which should be satisfied is there in the mind of the litigant a reasonable apprehension that he would not get a fair trial? The est is where there is a real likelihood of prejudice, but it does not require certainty. Real likelihood is the apprehension of a reasonable man apprised of the facts and not the suspicion of fools or capricious persons. 6. Shaheed Zulfikar Ali Bhutto bitterly complained before the Supreme Court that he had not been given a fair trial in the High Court. As its presiding judge, Mr. Justice Mushtaq Hussain, Chief Justice of the Lahore High Court, and also because the Central Executive Committee of the Pakistan People's Party, presided over by appellant, had joined issue with him in respect of statements made by him, Mr. Justice Mushtaq Hussain, within brackets, in his capacity as Chief Election Commissioner in August 1977. 7. He strongly criticized the observations made by High Court in para 609 to 616 of its judgment, describing him as a Muslim only by name and not living up to ideas or conduct prescribed for Muslim rulers of Islam. Mr. Bhutto stated that this criticism was unjustified and was clear evidence of bias against him. 8. The conduct of the members of the bench holding the trial as well as deciding the appeal is fully demonstrative of bias. Mr. Justice Maulvi Mushtaq Hussain, the then
where is this said? Paragraph 609 to 616?
My Lord, this is in the Lahore High Court judgment, the trial court's judgment.
And the citation is?
My Lord, the citation is PLD 1978.
PLD 1978?
Lahore.
Lahore. Page?
Just bear with me, man. 1978, Lahore, page 523, sir.
523?
523. This was a 5-member bench of the Lahore High Court which was conducting the trial. 8. The conduct of the members of the bench holding the trial as well as deciding the appeal is fully demonstrative of bias. Mr. Justice Maulvi Mushtaq Hussain, the then Chief Justice of the Lahore High Court, Lahore, was known to be biased against Shaheed Zulfikar Ali Bhutto due to being superseded. The entire legal fraternity and judicial community was aware of the temperament of Mr. Justice Maulvi Mushtaq Hussain, who never concealed his bias and hatred against Shaheed Zulfikar Ali Bhutto. It will not be out of place to mention here that international community showed complete no confidence in the judgment in issue by defeating Mr. Justice Anwarul Haq for the slot of International Court of Justice, whereas Mr. Justice Dorapate, one of the authors of dissenting judgment, was going to be elected unopposed, whose nomination had been withdrawn maliciously by the then caretaker government, who had come into power after toppling the democratically elected government of Mohatma Benazir Bhutto Shaheed.
Who was the Prime Minister in this caretaker government?
I believe it was Mr. Ghulam Mustafa Jatoi.
Are you sure?
1990, if I'm not wrong.
AG sir, was there any application made to the Lahore High Court showing no confidence in the then Chief Justice?
The record reflects that several applications were made. 9. Admission of former Chief Justice of Pakistan, Mr. Justice retired Naseem Hassan Shah, on print and electronic media that the decision of Shaheed Zulfikar Ali Bhutto's appeal was under coercion, does not leave any doubt in the mind of a sane and prudent person that it was a judicial murder which was decided and executed by dictator.
On what basis is this statement being made? Where is this admission?
My Lord, there were 2 interviews which were given by late Mr. Justice, retired Naseem Hassan Shah. One was, I believe, in 1996, but the other, more recent one in 2009.
Have you filed the transcript of the interview?
My Lord, I have to file.
To whom?
It was given, it was a television interview which he had recorded, which he had given, and it was also reported in the press.
Which channel or which person?
My Lord, I will have to place it on record.
Mr. Farooq Naik, do you know?
Farooq Naik would have to, but I am aware that there was an interview.
Mr. Iftikhar of Geo News. Mr. Iftikhar of Geo News.
Iftikhar what?
Iftikhar Ahmed, I think so. Iftikhar Ahmed.
Iftikhar Ahmed. Is he still in Geo?
Jawab De program.
Huh?
Jawab De program.
Is he still in Geo News?
He's still, I think, he's still there.
And which is the other interview?
Geo mein nahi hai, but he's still here. He's still here.
And which is the other interview? You said there are 2 interviews.
Yes. There was this rather old interview.
Yes, there was a second interview he had given to an unknown person, जिसमें उन्होंने कहा था कि कहते हैं जो मार्शल लॉ लगता है तो हमें मार्शल लॉ वालों की बात सुननी पड़ती है.
One thing which you may want to make a start, making a note of these things. We would want, we'll pass an order, but we'll want to have these, whatever.
We will give the videos as well as the transcripts.
Exactly.
We'll do that. Thank you, sir.
So just make a note of this.
Yes, I made a note of it.
Right.
Did he mention that who has coerced him?
Pardon?
Did he mention that who has coerced him?
Who has coerced him?
Yes.
Well, he didn't. He just used the word martial authorities. Because the martial law, General Ziaulak was in, and it was all orchestrated. The malicious design was orchestrated by General Ziaulak to execute Shaheed Zulfikar Ali Bhutto.
You mentioned an application being filed by your client, but that was not filed by you, or was it filed?
It was filed by me, I think, in 2018.
Yeah, Biju filed ki. That's by Mr. Raza Rabbani.
No, my lord, I filed this at CMA in 2018. I'll give you.
Now.
Now, अभी तो मैंने कोई फाइल नहीं किया है.
No.
अभी मैंने खाली live stream.
You filed it, or Mr. Raza Rabbani filed it?
I filed it, my lord.
Okay.
And recently I filed an application for live broadcasting.
Okay. I was in impression that Mr. Raza Rabbani has filed.
No, I filed it, my lord. Okay. Thank you.
Ji, please continue.
From paragraph 9, my lord. This admission tantamounts to violation of constitutional oath of office, which reads...
we skip the oath.
Naseem Hassan Shah's book, Constitution, Law in Pakistan, pages
Constitution
52 and 53. Kindly read and everything will be very clear.
Okay. Constitutional laws.
His book is Constitution, Law and Pakistan Affairs.
And Pakistan, and published by?
I do not know, but it's written by former Chief Justice.
Pages?
52. Pages are 52 and 53. And how this judgment was compiled, everything is written.
Mr. Farooq Naik, why are you so far away? We don't want to keep calling upon you or send some junior forward. And we would like this book to also, because he has referred to...
Can you read it?
No, we won't read it now. We'll let us finish the reference, but these things keep coming up, so we'll want to see the actual book. Please proceed.
This admission tantamounts to violation of constitutional oath of office, which reads as under.
So skip the oath, we can move on.
As such, Article 6 of the Constitution of the Islamic Republic of Pakistan is fully attracted in this case. Next para.
Then there is a statement of Naseem Hassan Shah in Nawai Waqt, Justice Anwar Haq is इंतहाई मुश्किल हालात में अजीम फैसले किए Naseem Hassan Shah.
So where are you referring to these things?
This is the 2nd of March 19.
No, this paper book, what is in your hand?
ये मैंने फाइल किया हुआ है.
Okay, it's on the record.
It's on record.
Is there a number to it?
Its number is 57888-2011.
578
CMA 5788-2009 and filed on 31st of December 2011.
2011. Thank you.
Kasuri Sahab, आप फॉर्मर चीफ जस्टिस नसीम हसन शाह साहब की स्टेटमेंट पर रिलाई कर रहे हैं?
नहीं, उसने अपना स्टेटमेंट
उन्होंने जो स्टेटमेंट
तारीफ कर रहा है जी
उन्होंने जो स्टेटमेंट्स दी,
बल्कि
सुन ले
अपनी किताब में लिखा है अपनी किताब में लिखा है कि चीफ जस्टिस ने कहा हमें चारों जजेस को एक क्वेश्चन दिया कि अपने जजमेंट देखो.
अच्छा, I think
उन्होंने कंपाइल किया.
नहीं, Kasuri Sahab, thank you for pointing this out. Attorney General, can you continue reading?
My Lord.
Because
paragraph 10. Yes. It is important to point out that in Sindh High Court Bar Association versus Federation of Pakistan, PLD 2009, Supreme Court 789, while dealing with the cases of the judges who had taken oath under PCO, the Honorable Supreme Court at page 805 held as under. The judges of the Supreme Court of Pakistan, if any, the Chief Justice of the High Court, if any, and the judges of any of the High Courts, if any, who stood appointed to the said offices prior to 3/11/2007, but who made oath or took oath of their respective offices in disobedience to the order passed by a 7-member bench of the Supreme Court of Pakistan on 3/11/2007 in CMA number 2869 of 2007 and Constitution Petition number 73 of 2007 shall be proceeded against under Article 209 of the Constitution. The Secretary of the Law Division of the Government of Pakistan shall take steps in the matter accordingly. 11. It is also important to mention that Justice Ghulam Safdar Shah, who wrote dissenting judgment in the Supreme Court, was subsequently witch-hunted and ultimately he had to leave the country in a miserable condition. 12. Whether it was legally justified to award capital punishment to Shaheed Zulfikar Ali Bhutto in the absence of any evidence worth name and merely on the basis of a totally cooked up and maneuvered story which never stood the test of routine cross-examination. 13. Whether both the Lahore High Court as well as Supreme Court were justified in awarding and maintaining the death sentence to Shaheed Zulfikar Ali Bhutto on the basis of a so-called threat to complainant which was blown out of proportion. 14. All important cases bearing important questions of law become legal precedents for the time to come, and they are quoted as citations, whereas the case of Shaheed Zulfikar Ali Bhutto is neither cited nor allowed to be quoted as a legal precedent by the courts of law. It is a judicial murder continuously haunting conscience of independent nation and legal judicial circles and hierarchies. 15. The unconstitutional and illegal ouster of Shaheed Zulfikar Ali Bhutto by a tyrant dictator and subsequent events was the root cause of initiation of an unprecedented criminal prosecution against deposed Prime Minister Shaheed Zulfikar Ali Bhutto. It is a matter of record which has been evidenced through the public statements of the cronies of tyrant dictator that he wanted to get rid of Qaeda-e-Awam by all means. The use of judiciary for execution of his malicious designs should not remain part of our legal history, as this country has started treading the path of democracy under an independent and proactive judiciary which has shown its resolve to defeat and foil any attempt to undermine or subvert the Constitution of the Islamic Republic of Pakistan. 16. Was it not legal duty of the regime to conduct an independent and fair judicial inquiry into the incident before starting criminal prosecution against Shaheed Zulfikar Ali Bhutto? 17. Was it safe administration of justice to award capital punishment to an accused of conspiracy for murder against whom the essential ingredients of conspiracy were not proved through reliable evidence? 18. Whether justice can be seen to have been done in this case while the appellant was deprived of his right of appeal before the High Court, being tried directly by the High Court. 19. Had he been tried by a sessions court, the trial judge would have been legally bound to follow the case law developed up to the time of trial, whereas the High Court ignored the same altogether. In this case, up to the time of trial and conviction, there was absolutely no precedent of conviction and sentence of capital punishment on the testimony of a prover. Neither in the judicial history of this country, murder trial of an accused was conducted by the High Court in its original jurisdiction, thereby denying the accused a valuable right of appeal before the High Court. The trial in this case was akin to the trial of Bhagat Singh, who too was tried, convicted and sentenced in Lahore on the testimony of a prover. 20. The judgment is per inquirium. According to Black's Law Dictionary, a judicial decision wrongly made is termed as per inquirium. The very fact that 3 honorable judges, Mr. Justice Ghulam Sattar Shah, Mr. Justice Dura Patel, and Mr. Justice Muhammad Halim, out of 7 gave a dissenting view, whereas 4 handpicked judges acted under the dictates of tyrant dictator, which makes it imperative for the Supreme Court of Pakistan to re-examine the law on the point of approver and criminal conspiracy. 21. It has been ruled by the Honorable Supreme Court of Pakistan in the case of Federation of Pakistan and others versus Mian Muhammad Nawaz Sharif, PLD 2009, Supreme Court 284, as below. Law is not a static object. It has to cope with the modern ideas and concepts and the disputes coming before the court for resolution, as the society with its environmental setup is continuously progressing. Law as well as its remedies are also changing with passage of time. 22. The question of bias needs to be revisited by the Supreme Court of Pakistan in the light of its judgment in the case of Asif Ali Zardari versus the State, PLD 2001, Supreme Court 685. 23. It was a split judgment of 4 versus 3. 4 convicting judges, that is Mr. Justice Sheikh Anwarul Haq, Chief Justice, Mr. Justice Muhammad Akram, Mr. Justice Karam Elai Chauhan, and Mr. Justice Naseem Hassan Shah, and 3 acquitting judges, that is Mr. Justice Ghulam Sattar Shah, Mr. Justice Dura Patel, and Mr. Justice Muhammad Halim, which needs to be revisited, especially after the admission of more than 1 members of the majority view, judges who, as mentioned supra, minced no words in stating that the judgment was given under undue influence exerted by the government of the day. Whereas it is noteworthy to see views expressed by the dissenting members of the bench concerning the evidence of approval, which read as under. As the prosecution case mainly hinges on the evidence of the approver Masood Mahmood, the question arises as to whether he should be believed or not. An overall examination of his evidence has led me to conclude that it is not of the quality on which reliance can be placed. Not only that, it suffers from inherent weaknesses, but also tends to show that he was a man of conscience, which conduct is wholly unnatural in the background of the facts elicited in the evidence. This feature had opened the gate for the argument as to whether the alleged order given to him by appellant Zulfiqar Ali Bhutto to kill Ahmed Raza Kasuri and his own reaction to it amounted to an agreement within the meaning of Section 120A PPC. However, this question has been resolved in the judgment of my learned brother G. Sattar Shah J, and I need not go into it. The High Court has construed the substantial omissions and improvements in his evidence as one of details or omissions of matters which have been brought on record by the public prosecutor by putting specific questions. In my opinion, these omissions and improvements vitally affect his truthfulness, and therefore in resolving it in favor of the prosecution in High Court, the High Court has given an illusory value to his evidence. If I may say so with respect, this was wholly unjustified. For the benefit of doubt in the evidence must in law go to the accused, as that is the elementary principle of criminal jurisprudence. 24. Accused is entitled to fair trial. Justice rushed is justice crushed. No murder case in Pakistan right from the independence of Pakistan to date has finally been decided in such a short span of time as in the referred case. This unholy and extraordinary haste in disposal of this case also clearly demonstrates bias. 25. It is enshrined in the Constitution of the Islamic Republic of Pakistan that it is one of the prime jurisdiction of the Supreme Court of Pakistan to do complete justice. Article 187, Clause 1. The assumption of original jurisdiction by the High Court for trial of a criminal case is a question of law which needs to be determined by this court, particularly in the light of universally recognized principle and a fundamental constitutional right in Pakistan pertaining to the due process. 26. At the relevant time, the Evidence Act 1872 was in field and Article 164 of Qanun-e-Shahadat order was not on the statute book. The learned High Court, while conducting the trial in hand, did not take into consideration a material fact that prosecution was not in possession of any evidence of conversation between the approver and the appellant. Surprisingly, this fact was also ignored by the Supreme Court while appraising the evidence in appellate jurisdiction. 27. I may make it very clear that coalition government headed by Pakistan People's Party is neither interested in any type of vengeance against anybody, nor the government believes in revenge. However, unprecedented incident of judicial murder of an international face of Pakistan's twice elected Prime Minister and father of the first Muslim woman Prime Minister and the father-in-law of the President of Pakistan, also twice elected and the founder of the largest democratic political force of the Federation, cannot be left unchecked under the dictates of justice, fair play and history, hence this reference.
Now, can we go to the relevant orders that you were referring to?
My Lord, if my Lords may kindly turn to order dated 21st of April 2011.
G.
The President of Pakistan has forwarded the instant reference under Article 186 of the Constitution. The facts.
Who was representing the President of Pakistan?
My Lord, it was Mr. Babar Awan at that time.
He's not representing Mr. Farooq
during the course of proceedings. What happened? He was representing the president in this case.
No, is he here in the courtroom or no?
He was representing the government at that time. Then his license got suspended.
No, okay.
His license got suspended.
So is he present in court?
No, he's not in court.
Okay.
Now who is representing the president?
The Attorney General.
Attorney General is
He will argue the case.
It is for the government to appoint any counsel.
At that time, the government chose to appoint Mr. Babar Awan as the counsel. And during the course of...
He was not Attorney General.
He was not, man.
Right.
And on 12th of January, while his license was suspended, on 12th of January 2012, while his license was suspended...
No, that's irrelevant.
Another matter.
Okay, now, please proceed. Please proceed. Yeah, I just wanted that clarification. Please proceed.
The facts and the President of Pakistan has forwarded the instant reference under Article 186 of the Constitution. The facts...
ये जो क्वेश्चन बने ये अब तो कुछ सप्लीमेंट्री रेफरेंस आया है उस रेफरेंस पे तो क्वेश्चन ऑफ लॉ कोई नहीं है बजाय ये कैसे बने ये क्वेश्चन
My Lord, in continuation of इससे पहले जो orders हुए थे, if I may read the order, it so appears that the court didn't perhaps made the same observation at that time which my Lord has just made, and then pursuant to that observation, these questions were then forwarded, and they were reproduced in this order. The facts and circumstances.
The picture, see, Awan filed this review, this reference, and for 6-7 days he was addressing this court. People who are friendly to me, they said, Mr. Kusuri, why don't you go there? I said, this can't proceed without me. Let court call me officially. Eventually court called me officially, and I filed about 80 pages.
Mr. Kusuri, I hope you don't mind. They just want to continue with the Attorney General, and then...
सफे का रिमाइंडर दिया ने उसको क्वेश्चन बना के उसको पुट करना शुरू किया he lost his temper and court ने उसके 2 साल के लिए उसका लाइसेंस कैंसिल कर दिया because he had nothing to answer. He was fobbling. He was short of answer. See,
let us hear the Attorney General Ji.
How is that man sitting?
My Lord, if my Lords may kindly turn to the previous order first.
In a very odd manner.
What is the date of previous order?
18th of April. I think this then answers why the questions were then forwarded and why they are recorded in the order dated. If my Lord may kindly turn to
let's go to this order you were saying.
So first, if I may take you to order dated 18/4/2011 and then to 21st April's order. 18th April's order.
18th April.
Yes. Because this is where I think the question arose, which questions have been referred to by the President. The Learned Counsel argued the case on the preliminary points relating to the questions of law in terms of Article 186(1) and 2 of the Constitution and needs further time to dilate upon the matter, adjourned to 21/4/2011. Now I'll read 21/4's order, 21st April's order. The President of Pakistan has forwarded the instant reference under Article 186 of the Constitution. The facts and circumstances relating to the questions formulated in the reference need not be detailed at this stage, except noting that Dr. Babar Awan, learned senior advocate for the referring authority, has dilated upon different aspects of the reference, which was received on 2nd April 2011 and was fixed for hearing on 13, 14 and 18 April 2011. Today, that is 21/4/2011, following questions have been forwarded in continuation of the reference which has already been submitted for the opinion of the court. 1.
This was a supplementary reference.
So they were, I think they were just forwarded by way of CMA, I believe they were placed on record.
We have not found out.
Could be treated as a supplementary reference. I believe
the questions have been framed and it was submitted subsequently.
Yes,
which are reflecting in this order.
My lord, and that's what I think the 18th April's hearing was about, where the court was trying to collect the questions. Let's see questions. Number 1. Whether the decision of the Lahore High Court as well as the Supreme Court of Pakistan in the murder trial against Shaheed Zulfikar Ali Bhutto meets the requirements of fundamental rights as guaranteed under Article 4, 1 and 2A, Article 8, Article 9, Article 10A due process, Article 14, Article 25 of the Constitution of the Islamic Republic of Pakistan. If it does not, its effect and consequences. 2. Whether the conviction leading to execution of Shaheed Zulfikar Ali Bhutto could be termed as a decision of the Supreme Court, binding on all other courts, being based upon or enunciating the principle of law in terms of Article 189 of the Constitution of the Islamic Republic of Pakistan. If not, its effect and consequences. 3. Whether in the peculiar circumstances of this case, awarding and maintaining the death sentence was justified, or it could amount to deliberate murder keeping in view the glaring bias against Shaheed Zulfikar Ali Bhutto. 4. Whether the decision in the case of murder trial against Shaheed Zulfikar Ali Bhutto fulfills the requirements of Islamic laws as codified in the Holy Quran and the Sunnah of the Holy Prophet Sallallahu Alaihi Wasallam. If so, whether present case is covered by a doctrine of repentance specifically mentioned in the following surahs of Holy Quran: Surah Nasa, verses 17 and 18, Surah Al-Baqarah, verses 159, 160 and 222, Surah Al-Ma'idah, verse 39, Surah Al-Araf, verse 153, Surah Al-Nihal, verse 119, and Surah Taha, verse 82, as well as Sunnah Ibn Majah, chapter 71, hadith number 395. What are effects and consequences of doctrine repentance? 5.
What does this mean? Why repentance?
I don't know if it is in relation to...
Mr. Farooq Naik, please enlighten us.
Yeah, I don't know if it is in relation to the statements made by a former judge.
Why repentance?
Maybe do
you have any idea?
To be very honest, no. But what I feel
is if you don't know,
repentance from the complainant side. That's what from the court comes to the mind.
We ask Mr. Raza Rabbani is here. Do you know? Ji?
I would not be able to assist you on that issue.
Okay. Kasuri sahab, aapko pata hai why the word repentance has been mentioned in this order? Why the repentance in question number 4 or whatever? What are the effects and consequences of doctrine of repentance? Why was this mentioned?
That was a very hard of hearing.
Doctrine of repentance.
तौबा करनी है।
तस्करा तौबा का तस्करा वो दिखा देना इनको जरा। नहीं आप पढ़ लीजिए।
ये लिखा है ना, what are the effects and consequences of doctrine of repentance? Maybe it was framed, the complainant.
Since he was there, he is the best person to tell us. Do you know why? Do you know why this was written?
बात ये है कि वो तो तौबा तो मैंने देनी थी ना।
जी
कि मैं कहता मैं माफ करता हूँ।
इस रेफरेंस में
तौबा माफी नहीं है।
वो तो दिया तो किसास में आ जाएंगे।
माफ कर देना और तौबा में फर्क होता है।
तौबा तो जो है वो तो अल्लाह ताला की ज़ात देनी होती है।
ठीक है आपको नहीं पता है कोई बात नहीं।
I'm not because I'm not expert.
No, it's okay.
Very fair about it.
नहीं, fair enough.
किसी आलम दीन को बुलाइए।
नहीं, fair enough. जी,
whether on the basis of conclusions arrived at and inferences drawn from the evidence material in the case, an order for conviction and sentence against Shaheed Zulfikar Ali Bhutto could have been recorded. So these are the 5 questions, and then paragraph number 2.
So 1 second, let us clarify one thing. Is this the presidential reference before us to answer these questions?
My Lord.
It is?
Yes.
That's your position?
That's what the order reflects.
Do you disagree with that?
No, not at all. This is the position, my lord.
Aage badhe.
2. In view of the importance of the presidential reference, senior advocates jurists Mrs. Ali Ahmed Kurd, Tariq Mahmood, Abdul Hafiz Pirzada, Fakhruddin G. Ibrahim, Khalid Anwar, Makhdoom Ali Khan, SM Zafar, Etazaz Ehsan, Zahurul Haq, and Abdul Latif Afridi are hereby appointed as a Maiki Curiae. Ms. Asma Jahangir, President, Supreme Court Bar Association, the Learned Attorney General for Pakistan, and the Learned Advocates General of all the provinces shall also appear and assist the court. 3.
Just 1 minute. So now some of them have passed away.
Yes, my lord.
Mr. Abdul Hafiz Pirzada has passed away.
Mr. Fakhruddin Ibrahim has passed away.
At least 7
SM Zafar.
The lawyers from KP, they have passed away. 2 lawyers.
SM Zafar, yes, he's passed away.
Mr. Latif Afridi and Mr. Zahurul Haq have also passed away.
And Ms. Asma Jahangir.
And Mr. Asma Jahangir.
My lord.
So we are left with, let's see.
Mr. Tariq Mahmood had excused.
Is Mr. Ali Ahmed Kurd present?
Yeah. Kurd sab to maujood hai.
Will you be assisting? Will you be assisting? एक सेकंड
Just 1 minute.
हमने देख लिया है. आप will you be assisting कुर्ता साहब? Yes, will you be assisting or not? Yes, we can't compel in amicus.
Sir, would you be assisting the honorable court?
Yes, sir. If
No, because that's enough. Is Mr. Tariq Mahmood present?
No, I think he's not well. He's excused himself.
And during the course of proceedings,
Kazuri sahab of Tashreef Rakshan.
On the objection,
he
had excused.
Mr. Khalid Anwar, is he present?
He also excused himself.
He is?
He excused himself. There's an order of the court on this issue.
Okay, and Mr. Makhdoom Ali Khan?
He's never excused himself. He's not here today.
Not here. Okay, 1 second. So,
and then Mr.
Okay, now we are left with who all? Mr. Etazaz Ehsan, where is he?
Present on behalf of Mr. Makhdoom Ali Khan. I'm present here on behalf of Mr. Makhdoom Ali Khan. He wasn't sure if your lordship will be issuing fresh notices to the amicus because, as noted by your lordship, many of them have passed away.
Just tell us about Mr. Makhdoom Ali Khan. Don't
if your lordship so desire, he will be present.
It's not our desire. He has been appointed amicus. Try to understand the matter.
My lord.
We cannot compel an amicus. Will he act as amicus or not?
He will be present, my lord.
He will act as amicus.
Yes, my lord.
Okay, fine. Mr. Etazaz Ehsan.
Associate, basically, he was amicus in this case before.
Please answer the question, don't make a speech. Yes, no.
He was appointed as a lawyer in this case later on in 2012.
Yes, no.
No, sir, because Mr. Farooq has instructed him not to appear in the court after.
Yes, no.
No, sir. No, sorry, not as a amicus, but he was lawyer in the last. If you see the last order,
have you asked you a long speech? Try to be brief. He doesn't want to come. Okay, fine. Now we're left with only 2 amicus then. One is Mr. Makhdoom Ali Khan, one is Mr. Ali Ahmed Kurd. And Tariq Mahmood Sahab is not well, you said. So we may also consider appointment of substitute amicus, and we'll take on suggestions on board. Just bear that in mind. Please continue reading.
Meanwhile, let the original record of the trial of Zulfikar Ali Bhutto's case be requisitioned from the Lahore High Court, enabling the learned counsel for the referring authority to obtain copies of the same if need be. For preparation of arguments, copies thereof shall also be supplied by him to all the above learned advocates. The office is directed to put up a note for constituting a larger bench.
Then the larger bench was constituted.
My lord.
Any significant order that we need to read?
My lord, there was one order.
One order I would like to.
We'll come to you, Mr. Farooq. Relax.
Okay.
My lord, there is this one order which related to, this is 3/5/2011.
3/5/2011. 3/5, not 2/5.
3/5.
G.
My lord.
3/5 पढ़िए.
G. Dr. Babar Awal, learned senior ASC, has addressed arguments at a considerable length, making reference to a number of documents to assist the court for the purpose of answering the questions framed in the reference. The learned counsel has also...
Attorney General, we just have 2nd of May, not 3rd.
3rd of May, sir.
अभी 5-2-3-5 हाँ नहीं तो इनका कसूर तो नहीं है
No copy of order dated
3-5-2011.
There is a 2nd May, and after 2nd May it was adjourned to 3rd May, and then
we just don't have the order.
No,
you don't have
two file है.
2-5 है, but the main file I have. So what we need to do also is make a copy of the entire order sheets.
नहीं वो है दूसरे फाइल है
आप दूसरे फाइल है कह रहे हैं
ब्लू फाइल देखें
Different file है.
चलिए पढ़ लेते हैं. Let's hear.
I'll read out slowly.
Yes, please
I'll read out slowly.
वो निकलवा लीजिए 3-5 वाला जजेस के लिए आपको भी निकालना है जी.
अब slowly मैं जरा पढ़ूंगा.
Please read it.
जी, the learned counsel has also moved an application, contents whereof are reproduced here and below, that the in charge of police station Ichra, Lahore, may be directed to produce the entire record along with register number 9 in respect of case against Mr. Zulfikar Ali Bhutto.
1 second, Mr. Attorney General, just a second. We've just found the order.
My lord.
There's a separate file with all the orders in it. So just a second.
Yes.
And
Page 32 पे. जी यू रीडिंग फ्रॉम द सेकंड पूरा ही पढ़ लेना डॉक्टर बाबर रवान
जी Dr. Babar Rahman, learned senior ASC, has addressed arguments at a considerable length, making reference to a number of documents to assist the court for the purpose of answering the questions framed in the reference. The learned counsel has also moved an application, contents whereof are reproduced here and below, that the in charge police station Ichra, Lahore, may be directed to produce the entire record along with register number 9 in respect of case against Mr. Zulfikar Ali Bhutto, former Prime Minister of Pakistan, in order to establish that the case was consigned after due investigation and on whose directions the same was reopened. 2. That the above request is made in the interest of justice. Next para. We consider that the production of the aforesaid record is just and proper during the hearing of the case. Therefore, the learned Advocate General Punjab is directed to procure the same in safe custody and produce it before the registrar, which will be examined in accordance with law. I can skip the next para. Qazi Muhammad Ashraf, learned senior advocate, has joined the proceedings as amicus. The office is directed to facilitate him. And
when is Mr. Qazi Ashraf present?
He's not present today.
So he was another amicus.
Yes, my lord. He was, and he appeared also a few times before this.
He's well.
He's well. I met him yesterday in the High Court.
And
he's okay. He's well. He's hard of hearing. He's hard of hearing a little bit.
Oh, practice कर रहे हैं इतना?
जी practice कर रहे हैं. मगर उनके अब जरा क्या कहते हैं थोड़े से
कराची वाले काजी
कराची वाले काजी.
Okay, I know.
कराची वाले.
Ji.
Any other order you would like?
Next following order, because this was the record of the police station.
4th
May. Dr. Babar Rahman, learned senior ASC, has addressed arguments and reads out various documents of legal order sheets of the High Court. 2. Khwaja Haris Ahmed, learned Advocate General Punjab, stated that the record of investigation of FIR number 402/1974, initially conducted wherein the case was consigned on 1/10/1974, being untraced, has not been made available. However, it is pointed to him that normally 4 copies of the police record are prepared. Therefore, further efforts should be made to locate the relevant record. 3. Secretary, Ministry of Law has produced copies of certain notifications that be placed on record. Now, the next order, 5/5/2011. Dr. Babar Rahman, learned senior ASC, continued arguments in support of his contention, during the course whereof he prominently made reference to the proceedings conducted after the dismissal of the review petition until the execution of sentence of death awarded to Mr. Zulfikar Ali Bhutto. Second para. In the meanwhile, Khwaja Haris Ahmed, learned Advocate General Punjab, has been called upon to explain as to whether the original record of FIR number 402/1974 registered at police station Ichra, Lahore, has been traced or not. As already observed, we consider it prima facie essential to understand the case from the record maintained by the police up till 1st September 1975, when reportedly it was consigned to record as untraced, but subsequent thereto, on the basis of some inquiry, which was entrusted to P.W. Abdul Ahad in respect of conduct of FSF personnel, investigation was started during the course whereof investigation of FIR number 402 of 1974 was revived. And in the meanwhile, Masood Mahmood and others started making incriminating statements, etc. in the case. He has explained that in spite of best efforts, record has not so far been made available. However, on being asked, he read out the contents of paragraph 8 of the judgment of the Lahore High Court, reported as PLD 1978, Lahore 523, as well as the relevant...
So the record was found or not found?
My lord, this original...
Rather than reading all these orders, just tell us in a nutshell, was it ever found or it's still untraced?
So this is, my lord, the original record from the police could not be found.
Untraced?
Ji.
Okay, so why read the rest of the order? Anything significant?
इसमें ये हुआ कि इसमें जो उसकी जो कॉपीज थी
FIA सर मैं बताया अच्छा का रिकॉर्ड आ गया हुआ है
नहीं वो जो आया है वो FIA की जो केस डायरीज थी वहां से आ गया वहां से आ गया
तो 3 बंडल्स हैं उसके 3 बंडल जो पुलिस के 3 बंडल
ओके ओके
जी जी
तो फाइल नंबर 6, 7 and 21
पुलिस की 3 फाइल आई हुई हैं चलिए ठीक है
6, 7 and 21 but we need not need.
No, tell us some relevant stuff.
My lord, after this, there were the arguments. So the only thing which was left, perhaps, was the record of the complaint, if I gathered it correctly.
Mr. Attorney General, I just have a question. Before we come to the question of law under 186 and the legal maintainability argument, as a matter of fact, could you tell us when the judgment was passed? Was the Constitution in abeyance at the time?
When the judgment was passed, yes, the Constitution.
At that time, could you give us a little background at that time? What was the political dispensation like at that time?
My lord.
When was in abeyance? Were there any appointments made during that period? That period needs to be understood when the judgment. That was 79. Either the trial period, maybe the whole thing. When it started, what was the political situation? Was the Constitution in abeyance at that time? Was there a constitutional deviation at that moment when this entire process took place? As a matter of fact, we still come to the question of maintainability, which is very important, we should have to answer. But as a matter of facts,
my lord,
maybe you want to put it together.
Ji. My lord, on the night of 4th and 5th July 1977,
we would like to see the notification, everything you see in front of us, part of the record.
ये नोट कर लीजिए बाद में you can provide them later. Please continue.
Another order. So it is another order I was requesting.
Please, which is the other one? Just tell us or you can read it. Which is the relevant ones? Orders. Let's read them.
My lord. This is an order dated 12th May.
12th May of which year?
2011.
You see, the precise question is, I'll rephrase it again for the Attorney General, maybe you want to put a file or a paper book on, that the entire trial going up to the Supreme Court was during a period when Constitution was in place, or was it not the case?
Yes.
Was there any constitutional deviation during this period when this entire case took place? That's all I want to know.
Yes. So the country was under martial law.
Sir, if your lordship would allow me,
I think we can take judicial notice of the fact
yes.
that
the country was under martial law up
no,
until
but I just want the dates and
but be precise. That's what my brother is saying. 12th May you wanted to read.
Order dated 12th May 2011. May I read, my lords?
12th May?
49.
12th May. From the perusal of record, it has transpired that after imposition of martial law on 5th July 1977, the criminal case against late Zulfikar Ali Bhutto, which stood consigned, was revived. It appears that in the meanwhile, a private complaint was also filed on behalf of the family members of late Nawab Muhammad Ahmad Khan Kasuri, which initially remained pending on the file of an additional session judge at Lahore. And perhaps in the month of August 1977, the same was transferred to the file of the Lahore High Court. The record so far received from the Lahore High Court through its registrar does not indicate that the record of this complaint has been transmitted. Therefore, the office is directed to requisition the same by sending a letter to the registrar, Lahore High Court, with direction to procure it and forward the same to this court. 2.
Why you read this?
Because this complaint has not come.
Which complaint?
Which has been mentioned.
The record of complaint has
record
not
of the complaint has not come. Now I'll read para 2 also.
A complaint regarding what?
See, complaint was
private complaint.
Private complaint.
So there was a private complaint also, which was
the significance.
Because that would show it was an afterthought what was going on. Because
paragraph 2,
private complaint.
Paragraph 2 अगर इजाजत हो पढ़ें clear हो जाएगा.
Okay.
Additionally, 5 different cases, probably under various provisions of the martial law regulations, were also registered against late Zulfikar Ali Bhutto. During the hearing of the criminal case before the 5-member bench of the Lahore High Court, and their hearing commenced at Court Lakhpat Jail from 2nd Feb 1978 by the tribunal headed by Mr. Justice Shafiur Rahman. The Registrar Lahore High Court is directed to procure the complete record of the said cases as well as transmit the same to the court. Sir, this is very important. It was a classified document, but it was declassified by the previous government. And this...
What is this tribunal headed by Justice Shafiur Rahman?
See, a tribunal was formed to look into the veracity of the FIRs, which were registered against late Zulfikar Ali Bhutto. And the tribunal came to the...
I'm pursuant to an order. What was it? How did it happen?
See, an order was passed by the government. A tribunal was formed. And as a consequence whereof, the tribunal formed the opinion and given the verdict that all cases were fake and they exonerated.
Where is that way?
That tribunal, it is still not here. We have got to...
No. Please. Please, let's. I'm just asking. Can you?
Private complaint जो है, that was filed on 31st of July 1977. Complaint was filed, and it was transferred.
Where is the record of the tribunal?
It was transferred to the High Court on 30th of September 1977. These are 2 dates.
Where is the record of the tribunal?
It was ordered by this honorable
Mr.
court.
Farooq Naik.
Ji, sir.
Please hear me carefully. If you never want this case heard, you can raise these objections. We will go by what is available before us. If something is not before us and you just make a statement, this happened or that happened, if there is some document before us, if you want some document sent for, then you have to be very specific. We will not accept a statement unless that happens. Otherwise, this will just delay the matter. I mean, it's been fixed after a very long time. And if it's not there, it's not there. So if you know how to access it, please tell us. We'll pass the requisite directions to order the production of it. So don't say this is not here, this is not here.
No, my lord. If your lord should allow me, it is written in the order. The Registrar Lahore High Court is directed. He is directed to procure the complete record.
What happened that I'm asking?
Nothing was written to them. I think so. This is what I've not seen any document.
We'll find out.
See, the registrar has to be written to bring the document on the record.
Many years have passed.
Yes.
Now, please, anything else you want to refer to?
And para 3 also, my lord.
Yes, read it.
It is important to note that 3 cases were registered.
These cases
were registered during the pendency of the trial of the murder case by the 5-member bench of the Lahore High Court. Therefore, we consider it appropriate to look into this record as well, because it is also likely to throw light on the facts and circumstances of the reference. 4. The Secretary Ministry of Interior, Government of Pakistan, and the Home Secretary, Government of Punjab, are directed to procure copy of the order passed by the martial authorities under MLR 12 of 1977, along with copies of...
I must stop you now. If you want something specific sent for, please submit an application or give us particulars, this, and who can we direct to send it for? We'll pass such an order.
I'll do it, my lord.
If it is not available, we can't do anything about it.
Your lordship is right. I'll move a proper CM listing the documents which I want to be...
Not only that, just don't say I want this document. You have to say where
they're lying.
Where would it be?
Definitely. I've got to show where they're lying.
One second. Now, anything else in the order that you want to read out?
My lord, just one point, just by way of information. The report, Justice Shafiur Rahman Tribunal report, was the government at that time, both the federal and provincial governments at that time had decided to make them public in 2011. during the course of proceedings of this reference.
So if it's public, then we'll have it?
Yes.
Somewhere or the other?
Gigi, it is duly recorded in paragraph 7 of the order which my learned friend was reading out. Now, the only thing which is not available is the complaint, the record of complaint.
We've understood. Anything further?
That's all. That's all.
Okay. Anything you want to say? No, now I'll just say let me just consult.
Okay.
अटॉर्नी जनरल साहब, ये कंप्लेंट जो आप कह रहे हैं बार बार प्राइवेट कंप्लेंट, इसमें तलबी हो गई थी मुलजम की?
एक तलबी हुई थी, ये पहले सेशंस में हुई थी, वहां से फिर ये हाई कोर्ट आ गई थी. एंड देयर वाज अ 2-member bench of the high court headed by Mr. Justice KMA Samdani at that time, who was seized of the matter on private complaint. अच्छा, जब ये प्राइवेट कंप्लेंट एट वन एंड चल रही थी, तो नीचे जब ट्रायल स्टार्ट हुआ, तो ट्रायल जो है वो हाई कोर्ट ने अंडर 526 अपने पास मंगवा लिया. तो उस वक्त चीफ जस्टिस ने 13 सितंबर 1977 को ये ऑर्डर किया कि ये अब यहां चलेगा. सो वो ट्रायल तो उधर चला, फिर वो प्राइवेट कंप्लेंट का पता नहीं लगा कि क्या हुआ वो 2-member बेंच.
ट्रायल के साथ मर्ज नहीं हुई एफआईआर एंड प्राइवेट कंप्लेंट.
आई हैव नॉट सीन इट फ्रॉम द
रिकॉर्ड. केस के तहत फिर कंप्लेंट पे पहले कार्रवाई होनी चाहिए
जी. वो फिर वो रिकॉर्ड में नहीं नजर आ रहा कि
किसी ने ऑब्जेक्शन किया डिफेंस साइड से, किसी ने कहा कि वो कंप्लेंट भी पड़ी है, इसको इकट्ठा रखे और उसको लगाएं पहले.
सर, जब एविडेंस पढ़ेंगे तो पता चल जाएगा उसमें ऑब्जेक्शंस लिए गए हैं.
Mr. Attorney General,
when we read the evidence.
Farooq Naik sir, just to get the course right of this matter, I think the first question you have to answer is the maintainability of this review, and we'll come to the facts later of the reference. So you'll have to assist us that under 186, what's the question of law? Because a decision has been given by the Supreme Court, review has also been dismissed. Now, that is the end of the matter. On what principle? आपके जो grounds अभी तक आपने दिखाए हमें, they are talking about as if you are vesting us, your argument is as if Article 186 vests another appellate jurisdiction to review the existing judgments of this court. And all the grounds that so far that we've seen are factual, relating to the judgment itself. Now the question is, there is finality attached to the decisions of the court, right or wrong. There could be bad decisions passed by the court, they're final. So the question is, what is the question of law that is for us to give our opinion on when the matter has already been settled by the Supreme Court? So if there is a question, you'll have to articulate, is it outside the judgment, or because the factual position of the judgment cannot be touched. That's been decided, review dismissed, that's the end of the matter. And we have no jurisdiction to review second review or look at it through a second appeal. There is no such concept under 186. So 186 at best would be a question of law which you will have to articulate before us. It cannot arise out of the factual position of the judgment because that's settled. We can't look at the facts. You'll have to go outside if at all there is any argument, which I don't see in the ground so far. So that's a difficult question. We already have decisions of this court and of the jurisdiction from India also, which say we can't touch a judgment given by this court and look at it at a policy level. If this happens, then tomorrow there could be references, we keep opening all our judgments. So you'll have to really articulate a point, under what basis do we go into 186, which I would imagine is a difficult one. So please concentrate on the maintainability and the constitutional question, how do we open this matter, if at all, how?
Your Lordship is right. See, under Article 186 of the Constitution, 3 tests have to be met before an opinion is given. It should be of public importance and question of law is involved. And if these 2 tests are met, then the 3rd test is with regard to giving an opinion by this Honorable Court.
Mr. Naik, the 186 says that the question of law is for the court to determine.
Yes.
The question of public importance is for the President to determine. That's for the President. We don't. That's not our problem. Our problem is, what's the question of law? Is the question of law saying this judgment is wrong? Is that a question of law? That is not, to my mind, frankly, speaking for myself, does not constitute a question of law that the judgment is wrong. There has to be more than that, and you'll have to come up with that argument as to what it is. Because if this is the policy, then tomorrow the President can start sending references, start revisiting all the judgments that we've ever given. That will not be a correct way of going about it, and you understand that.
I understand what
so we'll have to come up with, you'll have to come up with something to tell us. What is that novel argument that shows that 186 can be invoked in this matter? So, please, this is not easy.
And one thing I would like to add, Attorney General,
decide anything. We have to give the opinion.
Yes, my lord.
Therefore, what has been said till now, that relates to the determination of something by this court. That is not
it's actually a very serious question. Because when you say it's a question of law, the law has been decided in the judgment. Whatever judgment Supreme Court gives is the law of the land. So this is the law. So what's the question of law? So you can't say this judgment is wrong. It's not a question of law. There has to be something else.
Basically, the entire reference is based on the interview of the judge. Naseem Hussain Shah. That can be a question of law because it was a factual aspect that has been interviewed by some TV reporter after his retirement. And whether this can be a question of law because the entire reference, the crux of the reference is based on that interview. You have to address that, whether it will be converted into a question of law, whatever he has said. Because there were 3 dissenting judges also. He could have been a dissenting judge of that.
My lord.
What was the pressure on him? Why is...
Mr. Naik, let me take you to the real, what you think your question is. Your question is that during a deviation period or any dictatorship, the judiciary is not independent and they don't decide independently. That's a big assumption that you're throwing at us. You're saying that in any martial law, the judiciary is not independent. Hence, this is not a fair trial. You'll have to build a very strong case that how do you break that assumption that the judiciary is independent even during martial law period? And if it's not, what's the evidence? And if it's not, then what is the consequence? But that's a big assumption you're challenging. You're saying that in any deviation period, the judiciary is not independent. That's a big assumption to touch.
I will try to persuade your lordship on this point.
Can I just, before we get into... we're not...
Other things will follow.
Okay, now I think my brethren have raised some very important questions, and you also realize the significance of these questions. We need not tell very experienced counsel standing before us. There are undoubtedly constitutional questions involved, and we need 2 kinds of assistance. One on the constitutional plane, and the other, if you overcome the constitutional plane questions or questions of maintainability, then expertise on the criminal side. So I've noted that there were a number of constitutional experts who are no longer in this world. So I think we need to maybe appoint a few experts on both the matters as constitutional as well as the criminal. We'll first hear the constitutional experts, and then, depending on where we stand, proceed to hear the criminal experts. So I observe a notable constitutional lawyer, Mr. Raza Rabbani. Mr. Raza Rabbani, would you be willing to be appointed as amicus? But we want thorough, we'll extract every ounce from you. It may not be a pleasure by the end of it.
But we need to be independent.
Ek second. Sorry, why do you keep interrupting?
My case.
But we are appointing an amicus. You have an objection to amicus?
That's what he has raised.
I hope independent होना चाहिए. He's asking that.
It should be independent.
If you can propose an amicus, we'll hear your suggestion. Do you have a suggestion on constitutional thing? Mr. Kasuri, now we are asking you. Do you have a named constitutional expert?
Asking this question at random. Let me think it over.
Think. Okay, by all means think. Okay, now I don't know. We would also like, and the expertise on this bench, my colleague on the right is of course expert in criminal law, but it may help us to have another former judge. I don't know if does anyone have an objection to Justice Manzoor Malik being appointed as amicus? We leave it up to his lordship whether he wants to submit something in writing, whether he's agreeable to it or not. If anyone has any objection, please let us know, because I think there is considerable criminal expertise in the person of Justice Manzoor Malik. Would anyone have any objection?
I think it's a good choice, my lord. It's a good choice.
I don't have any objection.
It's a good choice.
If anyone else you can propose, the other day there was a very competent lawyer from Lahore, Mr. Salman Safdar. Do you have any objection? The two names have been given by my colleagues as well. Mr. Javed Khan, who was a former Attorney General, and Khwaja Haris, who was then the Advocate General, who has been in this case as well. So, thoughts on that? Anyone has any objections, so we can then have these names?
I think we should get some legal academic also. I think it's high time that we get some academics.
We may add to them when we're later on, if some colleague comes up with another name. So, but if anyone has any objection to these names, subject to their agreeing.
If your lordship would give, like Mr. Kasuri has sought some time, if your lordship will give me a few days, I'll think about it and give the name.
No, do you have any objection to these names? We can supplement
Khalid Javed Khan is a good lawyer, but I've got my doubts his practice on the criminal side.
No, constitutional.
Constitution is okay.
Constitution
is okay.
Like I said, there are two aspects to the case.
Constitution is okay. Good.
So, like you know, Mr. Raza Rabbani, I hope he doesn't mind my saying so. I will consider him a constitutional expert, maybe not a criminal expert. And there is Mr. Shahadat Awan here, who I will not consider. It will be the other way around.
Sir, Khalid Javed Khan is okay as far as the constitution is concerned.
There are a couple of other names also. Mr. Salahuddin Ahmed could be one of them. Mr. Faisal Siddiqui could be another. There could be the son of Justice Fakhruddin Ibrahim, Mr. Zahid Ibrahim. So we want amicus also by, as far as possible, by consent. So let it not be that we have a particular persuasion. We don't want that to come across at all. But we don't want long-winded speeches to be made at the bar. We would expect the amicus to submit things in writing. We will formulate what we think needs consideration, so they can think over them, submit them in writing, and we can call upon them if required, or if they want to add something to it. But we must have something in writing from them.
So right now I can give consent to two names. One is Mr. Justice Retired Manzoor Malik and Mr. Khalid Javed Khan. As for the other names are concerned, I'll have to consult my client, my lord.
Salahuddin and
the client is sitting very far away.
Both will assist properly.
No. We don't want to. You please address us. Ji.
सर ये दो नाम तो ठीक हैं.
ठीक है. तो ऐसे भी नाम होना चाहिए जो आपको नहीं पसंद है.
वो आपकी मर्जी है. That I leave it to your lordship then.
Otherwise the complainant may object.
आप वैसे ऐसे नाम देख लें जिससे आप इस रेफरेंस से फ्यूचर में कुछ अचीव करना चाहते हैं, बाकी प्राइम मिनिस्टर्स को सेव करना चाहते हैं, ऐसे नाम हो ताकि हमें गाइड करें.
My learned brother has mentioned the name of an academic, Mr. Yasir Qureshi.
He's at Oxford. He teaches constitutions.
No objection, my lord.
So we won't ask him to come. We can request for
send an
thing through email.
Academic is important to have an academic also. It's very important.
So, need to bring that culture into our
flair. It will bring a flair to it.
By the way, Kazuri Sahab, if you want to submit a name, okay. And if anyone else, you can give us a name. Who? Yes, fine. तो अच्छा, एक तो ये हो गई बात. The other thing is that there are other family members of the late Zulfiqar Ali Bhutto. They may want to engage counsel. We'll leave it open for them if they want to do so or not.
My Lord, only yes, there are, but as far as these...
Because primarily we're concerned with the decision affecting their lives as well.
We will ask them and let you know, my Lord.
We will just pass an order and that order becomes public so they can find out themselves.
Okay.
But we won't hear any person in person. We will only hear through counsel because these are all highly technical, legal, constitutional issues before us. So we won't grant any personal hearing. The only exception is, and we would request if Mr. Kasuri Sahab wants to engage a counsel, he can do so. He can represent himself. He's a senior counsel as it is. So if this is all right, then what date would you like to propose?
My Lord, after winter recess?
Yes, it has to be after winter recess.
Which winter? This winter, I think.
This winter, not the others.
The only one question, I just remembered. When was the last date of hearing in this case?
My Lord, it was 17th January 2012.
17th?
January 2012.
No, I have an order sheet of 12th November 2012.
My Lord, 12th? What?
November.
Sorry, 12th November, yes. Not
what happened then?
So with that background, they should come up in 2034.
Yes, 12th November.
Ek second, can you read that order of the 12th November?
Hello. Reference number 1. A request for adjournment is made on behalf of Chaudhry Etazaz Ahsan, Senior ASC, as he's gone to Karachi to attend the funeral ceremony of Mr. Iqbal Haider, Senior ASC, who was passed away on 11/11/2012. The request is allowed and the case is adjourned, date in office. Now, CMA 1993 of 2011, the order dated 17/11/2012, whereby the license of Mr. Babar Awan was temporarily suspended, was passed by 11-member bench, and while entertaining this civil miscellaneous application, such and such by a 3-member bench, it was observed that the request made by the applicant shall be taken into consideration by the requisite bench after its constitution. The office is directed to put up the matter for constitution of the requisite bench to hear the reference as well as this application. And I think this application was perhaps in relation to restoration of his license or something.
Why this case was not listed for 11 years?
Lord, that is for you to answer. That is for you to answer.
The court.
Sir, we have been making requests.
How very convenient.
Sir, we have been making requests innumerable times for the fixation of this reference.
This last bench comprised of 9 judges.
I would very humbly request this honorable court that the case should be adjourned after election because it might be used as an election campaign. No. And I do not want any party to be hurt because of this election, this proceedings. So I very humbly request that the date should be given after election.
Mr. Kasuri.
That's my request. Sir.
No, but I'll just
be wrong.
No, you're not wrong. You're not wrong. But let us be fair. This matter, this presidential reference, came to the Supreme Court in the year 2011. A number of presidential references came to the Supreme Court thereafter. They were taken up. There were also then election disputes, etc. So we won't do it. I mean, देर आए दुरुस्त आए, मगर अब इसको ये तो नहीं कि मुलतवी करते ही जाएं हम. देखिए नहीं, sorry to say, no.
Lawyer are a politician also, a very senior most politician of this country.
We don't recognize you are a politician.
Member of Parliament way back in 1960.
We don't accept you as a politician, nor do we accept Mr. Farooq Naik as a politician today.
I'm a humble advocate. I'm a humble advocate of this court.
With that, since I'm a founding father of Pakistan Constitution, with that background, I'm requesting you, please.
ठीक है, आप तशरीफ रखें.
In any country, a man who's a founding father of Constitution, just look at America.
तशरीफ रखें.
Their houses.
तशरीफ रखें.
It is in this country that there's no respect.
Mr. Kasuri, please take your seat. Thank you.
Yes. This is my request.
Thank you. So,
sir,
let's put a date in January then. Sorry, you want to add something?
Sir, may I say something?
Please do.
Which I am morally bound to express my view, sir. Actually, this matter, when this reference was filed before this Honorable Court under 186 of Constitution, from the very beginning proceeding till today, there were, I think 7 or 8 proceedings were conducted. Till the time the temporary
15. 15.
Yes, I was there. First, in the first hearing, I still very much remember, in the first hearing, before going to commence the proceedings, that time of the Honorable Bench, presided by the Honorable Chief Justice Chaudhry Zulfiqar, they said this matter is of a very, very important matter, and it is not upon the honorable judges to decide the matter. It is required. This bench requires that a panel of amicus curiae be appointed. So, first of all, the order first order was made. That was an appointment of a panel of 10.
We've read it already.
Sir, आप मेरी बात तो सुनिए सर. मैंने feel किया sir. I really felt. मैंने feel किया sir. So
sorry. We don't expect counsel to have feelings.
No, sir.
No. Please, we've already read the order. We've noted the number of amicus who've passed away. We have noticed. We have asked you if you are willing to continue.
Where is it?
No, but feelings keep at home.
Sir, what I felt. वो सारे जितने अमाइकस थे वो सारे एवरी प्रोसीडिंग्स में थे, तो उनमें से कुछ की डेथ हो गई है, मगर दिस ऑनरेबल कोर्ट डिडंट से ए फ्यू वर्ड्स ऑफ सॉरो. मिसाल के तौर पे सर, मेरी गदित में आई एम वन ऑफ द
कोई साहब, I must no, please take your seat now. No, plus that's it. No, please take your seat. I request you. Let us take the case with the seriousness it deserves. No, please. We will not permit this forum to become a talking point or any other reason. No, sorry, this will not be on. If you're talking about the case, yes. If you're talking about something else, please, there is a lot of media here. Go outside and make a statement. You are free to do so. चलिए अच्छा, अब हम ऑर्डर डिक्टेट कर रहे हैं. आपको रिक्वेस्ट ही कर सकते हैं ना कि आप तशरीफ रख लें. कसूरी साहब को भी रिक्वेस्ट कर सकते हैं.
थैंक यू सर.
जी शुक्रिया. इसमें वो जो अमाइकस थे वो कौन सा ऑर्डर था अटॉर्नी जनरल?
लॉर्ड, इट वाज 21st of April 2011.
21st of April.
मेन फाइल.
हाँ ठीक है.
इसमें नहीं लगा हुआ 21st में अप्रैल को. It's in the actual file. It starts with
paragraph number 2 of that order, 21st April 2011.
मेरा भी तो था वो आप जब फाइल देना इसमें है.
इसका page 26.
हाँ ठीक, I found it.
Second week. First week में नहीं है. Second week. कुछ लिखो दिल्ली को दे दो कुछ नहीं. सेकंड वीक तक तो उसके अलावा सरद से
बताना ऑर्डर में सेकंड वीक वो उसके अलावा कोई अच्छा इसमें लिखें. इसमें लिखें reference number 1 of 2011 was filed by the President of Pakistan under Article 186 of the Constitution of the Islamic Republic of Pakistan, which was entertained by this court. Full stop. A number of hearings took place, but unfortunately the matter was not concluded. The last hearing that took place, the last time when the matter was fixed in court was on 12th of November 2012, but unfortunately thereafter the matter was not fixed in court and has remained pending. Attorney General, can you also let us know the total number of presidential references that have been filed in the Supreme Court under 186? If such information can be, or as far back as you can go. Subsequently, a number of other presidential references were taken up, heard, and decided by this court. But this is the oldest pending remaining presidential reference. Is there any other presidential reference remaining before us?
I am not aware of any, sir.
Pending reference. Full stop. It merits determination. Therefore, it merits determination as early as possible. Full stop. Mr. Farooq Naik, learned senior ASC, has submitted an application, CMA number 8622 2018 2000 bracket closed, seeking to be heard. Seeking to be heard?
To be implemented as a party and heard.
Party in a presidential reference. Seeking to be heard.
To be heard.
Seeking to be heard. On behalf of. And
be a party to it, my lord. Be a party to the.
To be made a party to the presidential reference. As on behalf, the application has been submitted on behalf of Mr.
Bilawal Bhutto Zardari.
Mr. Bilawal Bhutto Zardari, who, Mr. Zulfikar Ali Bhutto. Full stop. I don't know if we can make a party in a presidential reference. We can certainly hear you, Mr.
Put them on notice and hear them. My lord, party, they can't be made party. You can put them on notice and hear them.
Mr. Farooq Naik, on a query, Mr. Farooq Naik states, any children of the late Mr. Bhutto alive?
No, my lord.
Children?
Only one daughter. She lives in London.
Okay. Mr. Farooq Naik informs us that there is only one child left, one daughter of the late Mr. Zulfikar Ali Bhutto who is still alive, and he has how many grandchildren? 4 other grandchildren. 4 okay, na? Altogether 5.
5, 6.
So altogether 5, 6.
5.
And there are other grandchildren.
Yes. Full stop.
Accordingly, we put Mr. Mr. Farooq Naik may represent
8 grandchildren. 8 grandchildren. 8.
Okay. No, please. 8 altogether, or 7 plus 1, or how many are there, Mr.
There's myself and my two sisters. Myself and my two sisters, Farouk.
Altogether 8. Altogether there are 8 grandchildren. Altogether there are 8 grandchildren. Full stop. Mr. Farouk Naik is put on notice to represent Mr. Bilawal Bhutto Zardari, and if any other and if the daughter and any other grandchild of the late Mr. Bhutto wants to be represented, they may engage counsel if they so deem appropriate. See? Okay, full stop. Learned Attorney General for Pakistan. Another learned Mr. Farouk Naik points out that he had moved another application seeking for live broadcast of these proceedings. However, the committee constituted in this regard had already enabled such live broadcast and recommended that it be so broadcast. And we believe it is being broadcast. I don't know if it's working or not.
It is working.
It's working. Justice Mazhar must have seen to it.
So the credit goes to Justice Mazhar and Justice Atharullah. So this application has become infructuous and is disposed of accordingly. Full stop. और कोई application है? अच्छा. We, pursuant to order dated 21st, which was the order appointing
1st April 2011.
Learned Attorney General of Pakistan read out the presidential reference. Learned Attorney General of Pakistan was asked whether the said presidential reference has been withdrawn by any successive president, or if the present president or government wants to withdraw it, and he stated that the presidential reference was not withdrawn, and the president and the government does not want to withdraw it either. Full stop. He accordingly, we asked him to read the presidential reference, which was read in court. And Learned Attorney General also read the certain other orders passed by this court, which he stated were relevant, particularly order dated, which was the questions?
21st April 2011.
Particularly order dated 21st April 2011, which he states that contain the questions which need to be addressed and answered by this court. Full stop. He has also pointed out order dated in the same order, in the same order, a number of Maiki were appointed, and amongst those, and a number of whom have passed away. And some are indisposed. However, Mr. Ali Ahmed Kurd, one of the Micas, is present in court, and on our query stated that he will assist the court. Full stop. In view of the fact that the matter before us involves significant and important. There is representation on behalf of Mr. Makhdum Ali Khan by Associate Counsel, who states that Mr. Makhdum Ali Khan is also ready to render assistance. Full stop. Since to fill the lacuna left by amicus earlier appointed, it would be appropriate to appoint further amicus, and in this regard Mr. Bhutto, we consider that the points require consideration are both constitutional, are first and foremost constitutional, particularly attending to the scope of powers under Article 186, the scope of Article 186 of the Constitution, and the nature of opinion that could be given. Full stop. Which would include the question of maintainability of the presidential reference. Full stop. Having attended this aspect of the matter,
जुल्फिकार अली भुट्टो से मुतालिक सदारती रेफरेंस चीफ जस्टिस ने आज की समात का हुक्मनामा लिखवाना शुरू कर दिया है। चीफ जस्टिस ने कहा इस रेफरेंस की कई समातें हुई, बदकिस्मती से हतमी शक्ल नहीं दी गई। रेफरेंस पर समात आखिरी बार 12 नवंबर 2012 को फिक्स की गई, लेकिन समात नहीं हो सकी। जुल्फिकार भुट्टो के नवासे बिलावल ने फारूक एचनाई के जरिए फरीक बनने की दरखास्त दी। क्या जुल्फिकार अली भुट्टो के बच्चे जिंदा हैं? चीफ जस्टिस ने इस्तफसार किया।
Practitioners or judges who have considerable criminal practice have undertaken a number of criminal cases. Full stop. In this regard, the name of Mr. Justice retired Manzoor Malik was proposed, and none present, and all present supported his appointment as amicus. Full stop. Accordingly, subject to his consent, Justice retired Manzoor Malik is appointed as amicus. Who may elect to either submit, if he agrees to either submit written concise statement I stand corrected, written amicus brief or address us in person. Full stop. Full stop. We note that Khwaja Haris was an Advocate General and was associated with this case when it was earlier heard. Therefore, he is no longer in his capacity as Advocate General Punjab. However, he is but since he is no longer the Advocate General of Punjab, he is also appointed as amicus. Full stop. Full stop. To gain the assistance of constitutional experts, in addition, on the criminal, to assist on the criminal side, Mr. Salman Safdar is also appointed amicus. To assist on constitutional matters, we appoint Mr. Raza Rabbani, who is present in court and has agreed to his appointment as such. comma. In addition, Mr. Khalid Javed Khan, former Attorney General of Pakistan. What was name?
Ji Salahuddin and Salahuddin Ahmed.
Mr. Salahuddin Ahmed and Mr. Faisal Siddiqui.
Mr. Zaid कर लीजिए सर, जाहिद को आपने कहा जाहिद इब्राहिम.
इन्हों को कर देते हैं.
जाहिद इब्राहिम को कर देते हैं.
इन्हों कर दें.
जाहिद को कर दीजिए.
जाहिद को भी कर देते हैं. Mr. Zaid Ibrahim. ठीक है. And Mr. Yasir Qureshi, who is a legal academic based station working at Oxford University, United Kingdom. Full stop. The learned amicus. Acha, full stop. The learned amicus should submit. The learned amicus appointed on the criminal aspect of the matter should attend to such aspect of the case, and those appointed with regard to constitutional determination to attend to constitutional matters. However, if any amicus wants to attend to the other aspect, they will be at liberty to do so. Full stop. One of the presidential reference had referred to an interview of one of the learned judges who sat on the bench of the Supreme, where the matter was earlier decided by the Supreme Court, which resulted in the decision reported in PLD.
The Supreme Court decision was 79, Supreme Court 53.
In Zulfikar Ali Bhutto v. the State, bracket mein PLD 1979, Supreme Court 38.
53, sir.
53 was
you interim order. 53, and the review mein bhi the. And the review decision therefrom reported as Zulfikar Ali Bhutto v. State, PLD 1979, Supreme Court 741.
Sir, may I make a submission?
Wait a minute. जुमला कैसे शुरू हुआ? Namely Mr. Justice Naseem Hassan Shah. Full stop. And a review and the interview given by him to Mr. Iftikhar Ahmed, then associated with GEO television, and Mr. Kasuri has also referred to. आपकी CMA कौन सी है, Kasuri साहब? CM has also referred to as
CMA 5788 of 2011.
2011. And has also referred to a civil miscellaneous application number 5788/2011, wherein he has filed extracts from the book published by the said judge, titled Constitution, Law and Pakistan Affairs. Italics में कर दें, and published by locally published. ठीक है, ये किताब हमें मिल गई, so आप भी देख लीजिएगा. Full stop. Mr. Farooq Naik, let notice be issued to. I've also heard an interview of Justice Zorab Patel.
Justice Zorab Patel ki bhi hai. We can provide the transcript as well as the video. I can do that.
You will do all of these things.
I'll do it.
Mr. Farooq Naik states that there was also an interview given by Justice Dorab Patel. And he will be providing the actual interview on a, what do you call it?
On a YouTube, we'll provide a
CD plus USB.
CD plus USB.
Oblique USB. And provide
a transcript
thereof. Full stop. Let notice be also issued to Geo Television because they may have some footage where they did not show. Sometimes if they cut out just important bit, to provide the entire interview that was referred to interview that was conducted by Mr. Iftikhar Ahmed. Correct?
Yes, sir.
So we have covered this.
So इसमें under instructions अगर sir
फाइंडिंग थी ये शफीक रहमान साहब की जो ट्रिब्यूनल की फाइंडिंग थी उसका क्या
सर उसकी वो ट्रिब्यूनल का वो रिपोर्ट मंगवा लीजिए बड़ी इंपॉर्टेंट है वो
आई नहीं है
अभी तक नहीं आई है सर
वो आपने फरमाया कि वो तो पब्लिक हो गई
पब्लिक हो गई थी
कैसे पब्लिक भी हो गया
कंप्लेंट का रिकॉर्ड था वो हाई कोर्ट से नहीं आया प्राइवेट कंप्लेंट
informs us that it is available.
जी वो हो गई थी पब्लिक भी हो गई थी it is only the private complaint record which the Lahore High Court could not send and which hasn't been sent thus far.
उसमें रेफरेंस होगा ना रिपोर्ट में
Mr. Farooq Naik,
रेफरेंस रिपोर्ट में होगा.
If you're going to have people standing behind you who do nothing other than show their face,
no sir.
I'm not asking you anything. Mr. Farooq Naik, you make them work.
Sir, they do work.
No. We're not saying anything.
Okay, I understand.
You make them work.
Definitely, sir.
Okay, so now we are told that report is available.
The report.
The report is available. It was made public by the government.
No, you did the Supreme Court.
Only the private.
I am appearing on behalf of Supreme Court Bar Association, sir. Notices were sent.
Okay. Asma Jahangir साहब को दिया था ना?
No, my lord.
नहीं उसमें दिया था ना notice.
She was president.
Yes, my lord.
So what about the president?
Sir, he's going alive.
No, I know you're the secretary. Do you represent the president?
No, sir, secretary. I'm secretary, sir.
No, we know you're a secretary.
President, sir, वो बाहर गए, sir.
इसमें मजीद लिखें. इसमें लिखें. In an earlier order, the president, the Supreme Court Bar Association was also issued notice, and the late Ms. Asma Jahangir was representing SCBA. Full stop. In case SCBA wants to be represented before this court, let them nominate a counsel of their choice.
अगर पाकिस्तान बार काउंसिल को भी कर दें सुप्रीम कोर्ट बार के साथ
I don't know, they may not be interested.
अफरीदी साहब जो थे ना अफरीदी साहब नुमाइंदे करे थे पाकिस्तान बार काउंसिल के जैसे आपकी
रिकॉर्ड है
तो जो भी आ जाए we can't force him to come. No, but we can't force him. If he's alive, then he should come. No, we're not. देखिए Kasuri साहब, it's not a question of defending anybody. It's just a question of a presidential reference. If he wants to come before us, certainly we'll hear him. We will not stop anyone unless it's completely irrelevant. Then we won't allow, or people coming and using the rostrum to make some sort of a speech. That what we won't permit. We will only hear constitutional and legal arguments, particularly pertaining to the scope of the advisory powers, and if we are satisfied, we proceed further. How to proceed further? Those are aspects which we will consider. जी, इसमें please write further with regard to the matters. We expect to be assisted on the questions which have already been framed by this court, by the learned, by this court. Full stop. Office is directed to send a copy of the reference along with all orders to the learned amicus to attend to the reference and the questions noted in order dated 21 April 2011, as well as those mentioned herein. Now, we may add after discussion some or better formulate questions later, but these are just roughly what we are saying. With regard to the criminal aspect of the case, we need to be assisted on the scope of direct criminal trial in a murder case by the High Court, precedents in this regard, the scope of whether there was any objection. How the trial came to be conducted by the High Court, and if there were any objections to the trial being conducted by the High Court, and if so, how the same were attended to, how the objections were attended to. Full stop. We also need to be assisted on the evidence, the significance of the evidence of approvers. Anything else?
That's it, sir.
There's a question of motive as well, because the case turned on the question of motive, but that is...
Why is he not coming forward?
Evidence.
मोटिव पे जी साहब आपने ये भी देखना है कि ये जो इंटरव्यूज होते हैं इनके रीजंस क्या होते हैं, क्या अचीव करना चाहते हैं, मकसद क्या?
Question of motive तो था in the context of motive of the for the prime. Minister in regards to the commission of offence.
Sir, इसमें सबसे important
But यहाँ
Have you
bias legal
issue?
लिखाए under instructions Faisal Siddiqui का नाम, we object to the name of Faisal Siddiqui as amicus.
Why?
Because of reasons क्या कहते हैं, government's reasons क्या कहते हैं. So there are reasons behind it. I don't want to disclose it in the bus. We object to it.
हम देख लेंगे, आपस में डिस्कस कर लेंगे. कसूरी साहब, आपको कोई ऑब्जेक्शन तो नहीं है
इसमें? जो
किसी नाम पे कोई और नाम आपको याद आ गया बता दें, कोई और नाम आपको याद आ गया हमें बता दें.
प्राइवेट
वो हमने कर लिया उनको, ठीक है.
वो तो आ गई ना.
तो हम we will discuss amongst ourselves.
ठीक है.
Please don't consider this the order.
No.
Wait for the written order.
Right.
It's always good to state what is in our mind.
Written order is the only order.
Anything else you want to say? Or we covered everything?
आप पूछ लेना. Salman Sadr.
We will fix it in the second week of January.
The week starting 15th January.
Sir, another name which we are Mr. Salman Sadr's name. And we object to it. How do you objection करते हैं? Senator Salman Sadr.
President reference the general is conducted. We will discuss some of that. We will discuss some one thing to clarify, it will be in January, we will fix a date in January, and then it will proceed day to day. But I have to check with all the judges availability. We'll give a date later, what the particular date is, and then please, we just want to finish it. No agenda.
The Constitution after 186, but once we cross the hurdle, then we come to the criminality of this.
Quite a hurdle. We want to and one all briefs, all concise statements and briefs by learned amicus to be submitted by put a day before that. So we should come to having those. And you would have also read each other.
Yes, sir, we'll move some same of bringing certain documents, additional documents on record. I'll do that. And before the date of hearing.
No. Not then. Do it today, tomorrow. We'll incorporate the order right now.
Okay, sir.
Otherwise, it will get delayed again.
No, we don't want to delay it. We just hear it in just 2 days, sir. Only 2 days.
No.
By tomorrow, by tomorrow, we'll fight the CM by tomorrow.
No, CM, you just tell us what document they are.
Sir,
okay, you want to get the CM by tomorrow. The order will not be signed tomorrow.
No, sir. The documents that are mentioned in the
Mr. Naik,
yes, sir.
Please submit it by tomorrow.
Okay.
We will, if it considered necessary, will incorporate that in the order today. Otherwise, we have to wait for the next date of hearing to pass an order, which will further delay the matter. You've understood it. So tomorrow, file it. So we won't sign this order till today. And if we find it necessary, we'll incorporate those in the order as well.
By mid-afternoon, tomorrow it will be filed. Before mid-afternoon, my lord.
Anything else? G. We would want assistance as well. Thank you, gentlemen.
Thank you, sir.
जुल्फिकार अली भुट्टो से मुतालिक सदारती रेफरेंस की समाअत चीफ जस्टिस इस वक्त हुक्मनामा लिखवा रहे हैं। हुक्मनामे में आ गया कल 186 के सदारती रेफरेंस दायर किया गया। आखिरकार रेफरेंस 2012 में सुना गया। किस्मती से रेफरेंस इसके बाद सुना नहीं गया और ज़ेर इल्तवा रहा। सुप्रीम कोर्ट का सदारती रेफरेंस पर समाअत जनवरी तक मुलतवी करने का फैसला। अदालत ने कहा अदालती मुअव्वनीन को नोटिस जारी करके जवाब दिया जाएगा। चीफ जस्टिस ने कहा आईनी मामला अदालती मुआवनत के लिए रजा रब्बानी से दरखास्त करेंगे। सलमान सफदर को फौजदारी मामलात पर मुआवनत के लिए बुलाया जाएगा। किसी और मामले पर कोई अदालती मुआवनत करना चाहे तो ताउन करेंगे। चीफ जस्टिस ने यह भी कहा जस्टिस नसीम हसन शाह के इंटरव्यू के रिकॉर्ड के लिए मुतालिका चैनल को लिखा जाएगा। हुक्मनामे के मुताबिक फारूक एच नाइक ने बिलावल भुट्टो की जानिब से फरीक बनने की दरखास्त दी। फारूक एच नाइक ने बताया कि जुल्फिकार भुट्टो की सिर्फ एक बेटी जिंदा है। अदालत को बताया गया कि जुल्फिकार भुट्टो के 8 पोते पोतियां नवासियां हैं। वो की जानिब से जो भी यकीन करना चाहे कर सकता है। सुप्रीम कोर्ट के हुक्मनामे के मुताबिक मामलात और क्रिमिनल मामलात पर भी माहिर मुआवन मुकर्रर कर देते हैं।
जी हाँ, उन्होंने कहा कि इस रेफरेंस की कई समाअत हुई, बदकिस्मती से हल्की शक्ल नहीं दी गई। रेफरेंस पर समाअत आखिरी 12 नवंबर 2012 को फिक्स की गई, लेकिन समाअत नहीं हो सकती। जुल्फिकार भुट्टो के नवासे बिलावल ने फारूक नायक के जरिए फरीक बनने की दरख्वास्त दी। क्या जुल्फिकार अली भुट्टो के बच्चे जिंदा हैं? इस्तफसार किया गया चीफ जस्टिस की जानिब से, जिस पर फारूक नायक ने जवाब दिया जुल्फिकार अली भुट्टो की एक बेटी है जो लंदन है। चीफ जस्टिस ने कहा जुल्फिकार अली भुट्टो के नवासे और दीगर अहल खाना की तरफ से आए हैं। चीफ जस्टिस ने कहा अगर कोई और भी आना चाहे तो अदालत फरीक बनाएगी।
समाअत अभी जारी है, वापस आएंगे इस ब्रेक के बाद।
सनसिल्क थिक एंड लॉन्ग, इसमें है योगर्ट प्रोटीन और केराटिन का सुपर मिक्स, जिससे बाल दिखे 2 गुना ज्यादा घने और मुमकिन करे हर हेयर स्टाइल। कैसा लगा हमारा स्टाइल इस शादी सीजन? जब बाल होते कोई भी स्टाइल करो पिक। हाय गर्ल्स, आई लव गोइंग आउट, लेकिन ये आउटिंग्स कर देती हैं मेरी स्किन को डल, छुप जाता है मेरा ग्लो। इसलिए मैं यूज करती हूँ पाम ऑयल नेचुरल्स मिल्क और रोज पेटल्स एक्सट्रैक्ट से बना, मेरी स्किन को बनाए सॉफ्ट एंड ग्लोइंग। पाम ऑयल नेचुरल्स, यू कैन फील इट।
पाकिस्तान जितने खाने बनाता है, नया ब्राइट उतने ही दाग मिटाता है,
क्योंकि नए ब्राइट का बेस्ट एवर फॉर्मूला गहराई से दाग निकाल।
तो सिर्फ पेंट रह गया है, उसका खर्चा 5 लाख। पेंट कौन सा लगाओगे?
कोई भी टोकन वाला।
टोकन वाला? पैसे मैं पेंट से दूंगा, टोकन के नहीं।
इतना तो एलियंस भी जानते हैं, पैसे पेंट के देने, टोकन के नहीं। मास्टर पेंट लगाए और टोकन के इजाफी खर्चे से छुटकारा पाए।
पैसे पेंट के दीजिए, टोकन के नहीं।
मास्टर पेंट्स, टोकन के बगैर पेंट्स बनाने वाला वाहिद ब्रांड।
दूध के बादल में कैल्शियम स्ट्रॉन्ग बनाए हमको, हम और ग्लूको मिल्क के साथ बढ़ो।
गोल्डन बर्ड ब्यूटी क्रीम, हुस्न जान की तारीफ मुमकिन नहीं।
ड्यूरेबल मोटर चाहे जितने ही कपड़ों की चलती जाए और रॉयल ड्रायर कपड़ों को करे इंस्टेंट ड्राई। रॉयल, साथ जिंदगी भर का।
ये है दुनिया का नंबर 1 सीरम, हाइड्रेट करे और हटाए 60% फाइन लाइंस सिर्फ 1 हफ्ते। हाइलुरोनिक एसिड सीरम बाय लॉरियल पेरिस,
Started from ₹17.99.
नूडा और कैडबरी चॉकलेट का मजेदार बूस्ट। कैडबरी मोरो अब एक न्यू लुक में। मोरो खाओ और रीसेट हो जाओ।
गोल्डन बर्ड ब्यूटी क्रीम, हुस्न जाना की तारीफ मुमकिन नहीं।
गोल्डन पर्ल हेल्दी व्हाइट मॉइस्चराइजिंग लोशन, एलोवेरा जेल और विटामिन B3 का स्पेशल फॉर्मूला स्किन को डीपली रिपेयर और नरिश करे। गोल्डन पर्ल हेल्दी व्हाइट मॉइस्चराइजिंग लोशन।
चलो आज खुद के लिए सिर्फ खानों को नहीं, खुद को भी रॉयल फील कराएं। इंट्रोड्यूसिंग मीज़ान रॉयल कुकिंग ऑयल, बिकॉज़ यू डिजर्व इट।
White glowing young skin,
मेड ऑल फेशियल।
गोल्डन पर्ल प्रोफेशनल फेशियल रेंज, फेशियल किट में भी।
अब हम सब फेशियल एक्सपर्ट।
वज़ीर आला पंजाब मोहसिन नकवी फैसलाबाद में मीडिया से गुफ्तगू कर रहे हैं।
से 1000 महीने में बनाता है, तो हम सिर्फ ये कह रहे हैं कि अपनी कॉस्ट दे दें, हुकूमत को वो ना करनी पड़े, वो भी जेब से देनी पड़े। बाकी कोई हम वहाँ पे ये नहीं है कि प्रॉफिट माना है, लेकिन मुझे फैसलाबाद का डेटा नहीं पता। लाहौर में तो 10% लोगों ने लाइन बनाया, यहाँ पे भी मुझे लगता है ये सिस्टम हमने ऑनलाइन लाइसेंस इसलिए कर दिया है कि आप लर्नर बना सकते हैं हर मिनट। कल का डेटा उसका मुझे नहीं पता, 200 ऑनलाइन हर मिनट में 200 ऑनलाइन लाइसेंस इशू हो रहे हैं इस टाइम। आप वो वेबसाइट में छपा हुआ है, आप ऑनलाइन जो लर्नर बनवा सकते हैं और फिर हर थाने में जाकर बनवा सकते हैं लर्नर। फैसिलिटी तो नहीं होता, लेकिन पब्लिक को यही मैसेज है कि लाइसेंस जरूर बनाओ, क्योंकि इसके बगैर हमारा नहीं है। हेलमेट जरूर, ये 2 चीज़ें सख्ती है। और ये तो नहीं हो सकता, दुनिया में नहीं होता है कि यार लाइसेंस के बगैर आप पूरी गाड़ियाँ चलाता हो।
अपनी कोशिश अपने बच्चों की
دعا کریں کچھ بہتر کریں گے.
واپس آئیں گے اس بریک کے بعد.
وائٹ موئسچرائزنگ لوشن, ایلو ویرا جیل اور وائٹامن B3 کا اسپیشل فارمولا اسکن کو ڈیپلی ریپیئر اور نرش کرے. گولڈن پیئر ہیلتھی وائٹ موئسچرائزنگ لوشن.
روپے میں تو ابھی اپنے قریبی ریٹیلر یا مائی ٹیلنور ایپ سے آفر لگوائیں.
گولڈن پیئر موئسچرائزنگ کریم کرے موئسچرائز اور ریوائٹلائز فار نرشڈ ینگر ریڈینٹ اسکن. گولڈن پیئر موئسچرائزنگ کریم, لو یور اسکن.
with Carrion.
دودھ کے بادل میں کیلشیم اسٹرانگ بنائے ہم کو, ہم اور گلوکوز کے ساتھ بڑھو.
MNU perfume body sprays for men and women.
Never let me go. X Smart Nova 7.
Just like a wow. Just looking like a wow.
تم اور میں الگ الگ سانچوں سے بنے, تم اور میں الگ الگ ذائقے رکھتے, مل جائے تو مزے کی نئی مٹھاس چکھتے. میرے ساتھ سے الگ الگ سانچوں سے بنے, تم اور میں الگ الگ ذائقے رکھتے, مل جائے تو مزے کی نئی مٹھاس چکھتے. میرے ساتھ سے نہیں کچھ بھی اوپر, سیدھی ساتھی خوشی ہے سوپر, سیدھی ساتھی خوشی ہے سوپر. گولڈن پیئر موئسچرائزنگ کریم کرے موئسچرائز اور ریوائٹلائز فار نرشڈ ینگر ریڈینٹ اسکن. گولڈن پیئر موئسچرائزنگ کریم, لو یور اسکن.
آج تو کچھ نیا ہو جائے, مومنٹ بھی تو اسپیشل ہے. چلو آج خود کے لیے ٹیبل سجائیں, صرف کھانوں کو نہیں خود کو بھی رائل فیل کرائیں. انٹروڈیوسنگ میزان رائل کوکنگ آئل, بیکاز یو ڈیزرو اٹ.
ویلکم بیک. نگراں وزیر اعظم انوار الحق کاکڑ نے ڈی آئی خان درابند کے پولیس اسٹیشن پر دہشت گرد حملے کی شدید مذمت کر دی. وزیر اعظم نے دہشت گرد حملے میں شہید پولیس اہلکاروں کی بلندی درجات کی دعا اور ان کے اہل خانہ سے اظہار تعزیت کیا. وزیر اعظم نے حملے کے نتیجے میں زخمی ہونے والوں کو ہر ممکن طبی امداد دینے کی ہدایت کی. کہا ایسی بزدلانہ کارروائیوں سے حوصلے پست نہیں کیے جا سکتے. قوم دہشت گردی کے خلاف جنگ کے شہداء کو سلام پیش کرتی ہے. آئی پی پی کی مرکزی مجلس عاملہ کا اجلاس آج پارٹی سیکریٹریٹ لاہور میں ہوگا. اجلاس میں نون لیگ کے ساتھ سیٹ ایڈجسٹمنٹ کے حوالے سے تجاویز پر مشاورت ہوگی. ذرائع کا کہنا ہے نون لیگ سے سیٹ ایڈجسٹمنٹ پر طریقہ کار مرتب کر لیا گیا ہے. جہاں آئی پی پی کا امیدوار مضبوط ہوگا وہاں نون لیگ کو سپورٹ کا کہا جائے گا. نون لیگ کے مضبوط امیدواروں کو مکمل سپورٹ کیا جائے گا. نگراں وزیر تجارت گوہر اعجاز کا پاکستانی وفد کے ہمراہ دورہ چین. اس دوران وفود کی سطح پر مذاکرات ہوئے. چینی سرمایہ کاروں کو گوادر پیٹرو کیمیکل انڈسٹریل پارک میں سرمایہ کاری کی دعوت دی گئی. نگراں وزیر تجارت کی ڈائنامک پاور کمپنی کے نمائندوں سے ملاقات ہوئی. نگراں وزیر تجارت نے کہا ہے چینی سرمایہ کاروں کی سرمایہ کاری کا تحفظ یقینی بنایا جائے گا. اب تک کے لیے اتنا ہی. دیکھتے رہیے ARY نیوز.
Golden Pearl 3D Skin Serum. Vitamin C se mile lighten and brighter skin. Hyaluronic acid hydrates and replants. Vitamin B3 reduce kare dark spots. Golden Pearl 3D Skin Serum.
सना, तुम्हारे प्रमोशन और रेस की ट्रीट खा रहा हूँ.
मेरे पास अभी कैश नहीं है.
जैज़ कैश ऐप से QR स्कैन करें या दुकान का कोड डालें क्योंकि हर कैशलेस पेमेंट के लिए जैज़ कैश है ना.
चलो आज खुद के लिए टेबल सजाएं. सिर्फ खानों को नहीं खुद को भी रॉयल फील कराएं. इंट्रोड्यूसिंग मीज़ान रॉयल कुकिंग ऑयल बिकॉज यू डिजर्व इट.
MNU perfume body sprays for men and women.
Never let me go.
तेरे मेरे साथ से नहीं कुछ भी ऊपरी सीधी साथी खुशी है सब पर.
Enjoy a soft, smooth and velvety skin this winter with internationally recognized Skin White Moisturizing Lotion. A unique non-oily blend of 100% pure goat's milk and other natural ingredients which quickly absorbs into dry, flaky and dull skin to keep it moisturized up to 12 hours. Skin White Moisturizing Lotions, your complete winter care.
بلاول بھٹو سپریم کورٹ کے باہر میڈیا سے گفتگو کر رہے ہیں.
جی بسم اللہ الرحمن الرحیم. السلام علیکم. آج ہم سپریم کورٹ آف پاکستان میں موجود ہیں جہاں 12 سال بعد جو صدر زرداری نے اپنا ریفرنس بھیجا تھا سپریم کورٹ کو کہ قائد اعظم شہید ذوالفقار علی بھٹو کے کیس میں وہ اپنا اختیار استعمال کرتے ہوئے یہ ریفرنس بھیجا سپریم کورٹ کو. اور آج 12 سال بعد اس کا ہیئرنگ ہوا. ہم جسٹس فائز عیسیٰ صاحب کا اور تمام جو ہمارا جج صاحبان ہیں کہ ہم ان کے شکر گزار ہیں کہ یہ فیصلہ لیا گیا اور آخر کار اس ریفرنس کو سنا جا رہا ہے. میں نے 2018 میں ایک ایپلیکیشن ڈالا تھا کہ اس کیس کو فوری سنا جائے اور فیصلہ دیا جائے اور ساتھ ساتھ ہمیں ایز اے لیگل ایئر ہمیں نمائندہ इस केस में बनाया जाए और हम उनका शुक्रगुजार हैं कि हमें वो इस केस में सुनने का मौका दिया जा रहा है और हमारा वकला भी हमारा नुमाइंदगी कर रहे हैं। हम समझते हैं कि ये जहाँ ये एक इम्तिहान है हमारा जुडिशरी के लिए, वहाँ साथ साथ एक बहुत बड़ा अपॉर्चुनिटी है। ज़रूर हमें कायदे अवाम शहीद जुल्फ़िकार अली भुट्टो के लिए इंसाफ चाहिए। ज़रूर जो भी मौक़िफ़ सदर पाकिस्तान ने अपना रेफरेंस में उठाया इस केस के बारे में, उनका सवाल का जवाब हमें चाहिए। ज़रूर वो जो आज तक दाग है इस इदारा पे, हमारा कानून पे, जहाँ ये डिसीजन सुनाया गया है, हम चाहेंगे कि उसको ख़त्म किया जाए। मगर हम ये क्यों चाहते हैं? इसलिए नहीं चाहते, हम नहीं समझते कि आप ये फैसला दे के हमें कायदे अवाम तो वापस नहीं दे सकते, हमें शहीद मोहतरमा बेनज़ीर भुट्टो वापस नहीं दिलवा सकते, हमें मीर मुर्तज़ा और शाहनवाज भुट्टो और मेरे पाकिस्तान पीपल्स पार्टी के जो कारकुन इस जदोजहद में शहीद हुए, वो जज साहिबान हमें वापस नहीं दे सकते। मगर जो जज साहिबान करते हैं उतना तो हम उम्मीद कर सकते हैं, उतना हम उम्मीद रखते हैं कि ज़रूर चीफ जस्टिस साहब और उनके ब्रदर जजेस जो है वो जो कर सकते हैं उतना तो कर लें कि कायदे अवाम शहीद जुल्फ़िकार अली भुट्टो अगर आज आपके सामने नहीं है, शहीद मोहतरमा बेनज़ीर भुट्टो आज आपके सामने नहीं है, तो मुझे इंसाफ दे, मुझे बताया जाए, इस कौम को बताया जाए कि कायदे अवाम शहीद जुल्फ़िकार अली भुट्टो बेकसूर था, जिसको हमने मर्डरर करार दे दिया, वो तो ही इज दी विक्टिम, और जो अक्यूज्ड है, जो एक्यूजेशन डालने वाले हैं, वो या ज़िया हक था या वो पूरा निज़ाम था जो उस वक्त एक सहूलतकार के रोल पे, एक को-एक्यूज के रोल पे हमारे नज़र में उन्होंने अपने आप का जो उस वक्त में तारीख में उनका जो रवैया था, चाहे वो आमरे वक्त था, चाहे वो उन जजेस थे, चाहे वो उन लॉयर्स थे, चाहे वो उन सियासतदान थे, हम उनके बारे में आपको पाकिस्तान के अवाम के सामने उनको बेनकाब करना पड़ेगा। पाकिस्तान के अवाम ने बहुत पहले ये फैसला कर लिया था कि कायदे अवाम बेगुनाह है। पाकिस्तान के अवाम ने बहुत पहले ये फैसला किया था कि हमारा कातिल कौन है। पाकिस्तान के अवाम को मालूम है कि हेनरी किसिंजर ने कहा था कि वी विल मेक अ हॉरेबल एग्जाम्पल ऑफ यू, मगर कायदे अवाम शहीद जुल्फ़िकार अली भुट्टो ने इस मुल्क को एटॉमिक पावर बनाया और अपने असूलों पे वो कॉम्प्रोमाइज नहीं की। इस मुल्क के अवाम को मालूम है कि कायदे अवाम वो मुस्लिम उम्मा का लीडर था जिन्होंने ना सिर्फ मुस्लिम उम्मा को इकट्ठा कर लिया, मगर मुस्लिम उम्मा को समझा दिया कि आपके पास क्या ताकत है। उन जमाने में भी हमारा फ़लस्तीनी बहन भाइयों के खिलाफ जो जुल्म हो रहा था, वो उन जमाने के इस्लामिक क़यादत थे जिन्होंने ये फैसला किया कि और उनको ये कायदे अवाम था जिसने समझाया कि आपके पास जो तेल है वो ना सिर्फ आपकी मुआशी तौर पे फ़ायदा दे सकता है, मगर ये तेल आपका ताकत है। और उन्होंने मिलके ये फैसला किया, इन्होंने मिलके ये फैसला किया कि जब तक हमारे फ़लस्तीन के जो बहन भाई है उनको इंसाफ ना दिया जाए तो उन्होंने एम्बार्गो रखा और उनका कॉन्सिक्वेंसेस उन सब ने भुगता। जो हर एक जो मुस्लिम उम्मा का कायद था, जो इस फैसले में शरीक थे, दे डिड नॉट डाई ए नेचुरल डेथ। और हमारा अदालत से ये अपील है कि आपने तारीख को दुरुस्त करना है, आपने अपने हाथों से ये खून धोना है, आपने जो इस जुर्म में मुलव्विस थे उनको बेनकाब करना है। पाकिस्तान के अवाम को ये समझ से बाहर है कि कैसे जिस साहब पे कायदे अवाम शहीद जुल्फिकार अली भुट्टो पे जो इल्ज़ाम था कि आपने फला बंदे को कत्ल करने की कोशिश की, वो बंदा जिंदा है। आज भी आपके सामने प्रेस कॉन्फ्रेंसेस कर रहा था, कोर्ट में मौजूद था, मगर शहीद जुल्फिकार अली भुट्टो को इसको कत्ल करने में शहीद कर दिया गया। आप सब उसको शहीद कहते हैं। क्या किसी कातिल को शहीद कहा जाता है? आप मुझे बताएं, इज इट इन आवर कॉन्स्टिट्यूशन इसकी इजाजत देता है? हमारा कानून इसका इजाजत देता है? इस्लामिक जूरिस्प्रूडेंस क्या इसका इजाजत देता है? द लॉज ऑफ नेचुरल जस्टिस क्या वो उसको इजाजत देता है कि अगर आप अक्यूज्ड हो एक कंस्पिरेसी का और वो बंदा जिंदा है तो सजाए मौत बनता है? ये तो बहुत बड़ा सवाल निशान है कि आपने तो फांसी का सजा सुना दिया, मगर इस्लाम में, कानून में, आईन में इस सजा की गुंजाइश नहीं है। तो हम उम्मीद करते हैं कि हमारा अदलिया ने यह फैसला कर लिया कि ना सिर्फ तारीख को दुरुस्त करना है, ना सिर्फ को कानून को दुरुस्त करना है, मगर पाकिस्तान के अवाम का जो एतमाद है इस इदारा में उसके भी हमें बहाल करना पड़ेगा। और साथ साथ ऐसे फैसला होना चाहिए कि हमेशा के लिए वो दरवाजा बंद किया जाए और हम आगे जाके हमारा कोई अदलिया इस किस्म का काम नहीं कर सके। कहा जाता है कि उस केस का जो वो केस है वो कभी पाकिस्तान की जुडिशियल हिस्ट्री में इस केस का रेफरेंस नहीं दिया जाता। दिस केस इज नेवर कोटेड एज अ प्रेसिडेंट। नाउ व्हाइल द केस मे बी विद द केस इटसेल्फ मे नॉट बी कोटेड एज अ प्रेसिडेंट, जिस तरीके से इस केस का फैसला करवाया गया वो प्रेसिडेंट तो चलता आ रहा है। और हम जस्टिस फाइज इज्जत से ये उम्मीद रखते हैं, इन तमाम जुडिशरी से, एवरी सिंगल जज ऑफ द सुप्रीम कोर्ट से ये उम्मीद रखते हैं, ये दरख्वास्त करते हैं, ये अपील करते हैं कि आपने वो दरवाजा भी बंद करना है। क्योंकि ये भी ना सोचे कि वो हमारा सुप्रीम कोर्ट को इस तरीके से कंट्रोल करने की कोशिश भी ना करे आगे जाके। मैं आप सबका बहुत शुक्रगुजार हूँ, पाकिस्तान पीपल्स पार्टी के तमाम कारकुन जिन्होंने ये जदोजहद लड़ा है, और इंशाअल्लाह ताला हम ये केस लड़ते रहेंगे और उम्मीद है कि हमें अफाज मिल।
अपने फैसलों को दुरुस्त कर लेगी, मगर क्या आप और आपके जितने भी सियासतदान हैं दूसरी जमातों
Sir, I think the first step जिस कायदे अवाम शहीद जुल्फिकार अली भुट्टो के केस में तो आप इंसाफ दो। उस आइन का जिनका इन्होंने हर जस्टिस ने ओथ लिया है कि हम इसका तहफ़्फ़ुज़ करेंगे, उसका बानी को कत्ल किया गया, शहीद किया गया, उसमें हमारा एक पूरा इतने साल गुजर चुके हैं। तो उम्मीद है जब हमें इंसाफ मिलेगा तो फिर जो आपके सवाल है उनको भी हम रोक सकेंगे।
आज की शहीद भुट्टो हो या यूसुफ रज़ा गिलानी केस हो या उसके बाद शहीद रानी हो, एक तारीख है पाकिस्तान पीपल्स पार्टी की कुर्बानियों की। और इस तरह के और भी फैसले आए हैं। जब पंजाब के वज़ीर आज़म को तो यहाँ से रिलीफ मिलता था, लेकिन पीपल्स पार्टी के को यहाँ से कभी भी रिलीफ नहीं मिला। उसी तरह की तलवारें फिर चल रही हैं, चाहे वो पनामा पे हो और या चाहे जो अभी सूरत हाल हो। तो आपने जिस तरह कहा कि हम रास्ता बंद करना चाहते हैं, तो आप समझते हैं एक ज़ीर सियासतदान है, यंगस्टर है, कि आगे आप खुद बातचीत शुरू करें सियासी लीडर से।
तो आपका सवाल का जो शुरू था वो बहुत अच्छा था, मगर उम्मीद है कि इस बार सिर्फ और सिर्फ पीपल्स पार्टी को और पाकिस्तान के अवाम को कायदे अवाम के केस में रिलीफ मिलेगा। बाकी जमातों का भी हक है, उनको भी इंसाफ मिलना चाहिए, चाहे वो मुस्लिम लीग नवाज हो, चाहे वो तरीके इंसाफ हो, उनको भी हर किसी को ये हक है कि आइन कानून के मुताबिक उनका केसेस का फैसला किया जाए। मगर कायदे अवाम शहीद जुल्फिकार अली भुट्टो का केस कब से पेंडिंग है, किसी और को इंसाफ मिल ही नहीं सकता है जब तक कायदे अवाम को इंसाफ। पाकिस्तान के अवाम इस इदारा साफ देने वाला इदारा मानेगा नहीं जब तक कायदे अवाम शहीद जुल्फिकार अली भुट्टो को इंसाफ मिलेगा। फिर शायद उनको ये उम्मीद हो कि आम पाकिस्तानी को भी इस इदारा से इंसाफ मिल सकता है।
क्या पीपल्स पार्टी मुतालिबा करेगी उनके खिलाफ?
देखो, जनरल ज़ियाउल हक की आमरीत, जो जज साहिबान इस मुलविस थे, हम तो समझते हैं बिल्कुल। इनफैक्ट द लॉयर्स, द पॉलिटिशियंस, the dictator, the judiciary, the other people who lied and are still to this day lying in order for this to take place, वो सब इस कौम के नजरे में इन्होंने गुनाह किया है, वो मैं समझता हूँ कि अवाम के सामने आना चाहिए। और ये जो सुप्रीम कोर्ट है, हम उम्मीद रखते हैं कि वो ना सिर्फ अपने ऊपर जो दाग है, मगर जो तमाम सूरत हाल है उसके पास एक मौका है जितना उसमें वो इंसाफ दे सकते हैं।
कर रहे हैं कि आपको इंसाफ मिलेगा, अच्छी बात है। लेकिन आप देखते हैं कि एक तरफ जोर में दहशतगर्दी भी है, दहशतगर्दी आज भी डी खान के अंदर पुलिस वाले शहीद हुए, आवाम शहीद हुए हैं हजारों की तादाद में। क्या जो दहशतगर्दी के मुकदमात है, जो उन पर भी आपके मुतालबा रखेंगे कि उनके हवाले से भी अदलिया फैसले दे?
मेरा ख्याल में बिल्कुल हम चाहते हैं कि दहशतगर्दों के खिलाफ फैसले आए, केसेस किया जाए, लेकिन हमारा जुडिशरी ने काफ़ी बहादुरी दिखाया है जहाँ तक दहशतगर्दी के वाक़े के। आप इसी जस्टिस फायज़ ईसा का एग्जाम्पल देखें जो क्वेटा के वकला के साथ हुआ था। जस्टिस फायज़ ईसा ने एक तगड़ा फैसला भी सुनाया था और उम्मीद है उस पर अमल दरामद भी होगी। हमारा हाई कोर्ट जजेस ने जुडिशरी में से जो लोग हैं उन्होंने शहादत भी कबूल किया है, दहशतगर्दों की हमलों में शहीद हुए हैं। तो इसमें हम सब दहशतगर्दी के शिकार हुए हैं और हम सबको मिलकर इसका मुकाबला करना है। देखो, जहाँ तक ये साहब है, हम सब जानते हैं, आप भी जानते हैं, आप भी जानते हैं कि ये किसका खिलौना है और उन्होंने ही इसको लॉन्च किया होगा। वैसे मेरे लियारी के जियाले जो है ना, वो बहुत मज़ेदार नारे बनाते हैं। तो इन्होंने कल मुझे एक मैसेज भेजा जब ये सब कुछ चल रहा था कि मियाँ तेरे जानिसार बशीर मेमन रावनवाल। तो ये आपका सवाल का जवाब है।
आप ये बता दें कि लेवल एक लाडली के लिए दी गई, अब एक और लाडली के लिए दी जा रही है। क्या पीपल्स पार्टी के लिए लेवल प्लेइंग फील्ड मिलेगी? इलेक्शन में नहीं मिलेगी? जुलाई साहब कहते हैं कि इलेक्शन हो सकता है डिले हो जाए 10-20 दिन, तो उसमें क्या कहेंगे?
सवाल ले रहा साहब के बराबर आपने सुप्रीम कोर्ट के हवाले से बात की है और इस पर एतमाद का भी इजहार किया है। इसी सुप्रीम कोर्ट ने 8 फरवरी को इंतखाबात के हवाले से बात की। आसिफ जरदारी साहब ने रात को इंटरव्यू में ये बात कही कि इंतखाबात आगे भी जा सकते हैं।
जहाँ तक
सर सवाल ये है कि राव अनवार ने बड़े सीनियर इल्जामात लगाए हैं, इस पर आप क्या कहेंगे?
जहाँ तक उस सवाल का मैंने जवाब दे दिया। जहाँ तक फरवरी 8 का इलेक्शन दिन है, उस पे जस्टिस फायज़ ईसा साहब ने खुद कहा था कि पत्थर में लिखा हुआ है, कुछ सवाल ना करे कि फरवरी 8 के आगे इलेक्शंस हो सकते हैं। जहाँ तक सदर जरदारी का बयान था, मेरा ख्याल में अगर आप तफसील से उस इंटरव्यू को देखते हैं तो सदर जरदारी कह रहा था कि इलेक्शंस टाइम पे होंगे। जब उसको मजीद प्रेस किया गया, उसने आपका जो जवाब है वो दिया और वो उसको आप आउट ऑफ कॉन्टेक्स्ट ट्विटर पे, इसलिए वालिद साहब ये सोशल मीडिया का और जो ये नया तरीक़ेकार है उसमें इस तरीके से पेश किया जा रहा है। तो मैं आपका शुक्रिया करता हूँ कि आपने मुझे ये मौका दिया कि मैं क्लैरिफाई करूँ। पाकिस्तान पीपल्स पार्टी जस्टिस फाइज ईसा पे 100% एतमाद करते हैं और ख़ास तौर आज के बाद जो ये सिलसिला चलता आ रहा है, तो जस्टिस फाइज ईसा साहब ने वाज़े तौर पे, ताकि कहीं कोने में कन्फ्यूजन ना हो, कि फरवरी 8 पे पत्थर में लिखा हुआ है, कोई उस पर बात भी ना करे। इलेक्शंस होंगे। अगर मुझे कोई ऐसे लगता है कि इसमें कोई तब्दीली आया है, तो आई बी द फर्स्ट पर्सन टू कम।
कब तक ये सिलसिला जारी रहेगा? कब तक ये सिलसिला जारी रहेगा कि जो पॉलिटिकल फोर्सेज हैं उनको जो है डिक्टेटर जो है सर, कब तक ये सिलसिला जारी रहेगा? सर, कब तक ये सिलसिला जारी रहेगा कि जो डेमोक्रेटिक फोर्सेज है किया कि जो चार्टर ऑफ डेमोक्रेसी उसको रिवाइव किया जाए और ये सारी चीजें एक होल थम न्यू चार्टर ऑफ डेमोक्रेसी आए? ये बहुत पुरानी तो पाकिस्तान पीपल्स पार्टी का मौक़िफ़ है, मुतालबा है कि हम सब मिल के अपने दायरे में रह के काम करें। और इसका मतलब ये है कि सारे बाकी इदारे भी अपने दायरे में रह के काम करें और सियासतदान भी सियासत के दायरे में रह के और जमहूरियत के दायरे में रह के ही काम करें। तब ये मुल्क चल सकेगा, तब हमारा मईशत चल सकेगा, तब हम एक मॉडर्न रियासत बन सकेंगे। अफसोस के साथ आपको बताना पड़ रहा है कि मैं इन पुराने सियासतदानों का पुराने सियासत को अब देख चुका हूँ और उनका कोई रवैया नहीं है कि इन्होंने अपने रवैया चेंज करना है। उन्होंने वही पुराने सियासत करना है जिससे ना ये मुल्क तरक्की करेगा, ना हमारा मईशत तरक्की करेगा, ना हम इस हाइपर पार्टिसान हाइपर पोलराइज एनवायरनमेंट से निकल सकेंगे। हमें इस बुखार को तोड़ना पड़ेगा जहां सियासत को, सियासी इख्तलाफात को हमने ज़ाती दुश्मनी पे पहुंचाया। और अगर आप ये नहीं पहचानेंगे कि हम सब पाकिस्तानी हैं, चाहे आप पीपल्स पार्टी से ताल्लुक़ रखें, आप नून लीग से ताल्लुक़ रखें, आप पीटीआई से ताल्लुक़ रखें, आप सब पाकिस्तानी हैं, आप सब मुहिब्बे वतन हैं। आप सब ये फैसला करें कि हम इख्तलाफात भी रखेंगे मगर साथ मिलकर इन तमाम मसाइल का हल निकालना पड़ेगा। मेरे ख्याल में कि जो पुराने तरीक़ेकार है इसको जितना जल्दी हम दफन कर सकते हैं। ये नफरत की सियासत, ये तकसीम की सियासत और एक नया सियासत मुतारफ करे, फिर हम पाकिस्तान के अवाम
जुल्फिकार अली भुट्टो की फांसी से मुतालिक सदारती रेफरेंस की सुप्रीम कोर्ट में के बाद चेयरमैन पीपल्स पार्टी बिलावल भुट्टो जरदारी मीडिया से बात कर रहे थे। उनका कहना था कि जजेस से दरख्वास्त करूंगा कि वो दरवाजा भी बंद करें कि कोई अदालतों को इस्तेमाल न कर सके। आइन और कानून में इस सजा की गुंजाइश नहीं। बिलावल भुट्टो ने कहा, उम्मीद करते हैं कि अदलिया फैसला करेगी, तारीख और कानून को दुरुस्त करना है। पाकिस्तानी अवाम का इस इदारे पर एतमाद को भी बहाल करना पड़ेगा। जब तक कायदे अवाम को इंसाफ नहीं मिलता, अवाम का एतमाद बहाल नहीं होगा।
साफर केस में फर्दे जुर्म आज भी आयद न हो सकी। खुसूसी अदालत ने केस की समाअत कल सुबह तक मुलतवी कर दी। वकील सफाई की जानिब से दायर 6 दरख्वास्तें निपटा दी गई हैं। अहम खबर से आपको आगाह कर रहे हैं। साफर केस में फर्दे जुर्म आज भी आयद न हो सकी। खुसूसी अदालत ने केस की समाअत कल सुबह तक मुलतवी कर दी। वकील सफाई की जानिब से दायर 6 दरख्वास्तें निपटा दी गई हैं।
कराची ले चलेंगे। एम के इमरान खालिद मकबूल सिद्दीकी के मीडिया से बात कर रहे हैं।
आज हमारे सब्र का आखिरी पैमाना था, इसको छलकने मत दीजिएगा। इसमें तेजाब भरा हुआ है, इसमें बारूद भरा हुआ है, इसमें आग भरी हुई है। अब किसी और ने किया तो इस शहर के अमन की सारी जिम्मेदारी उन पे होगी। मैं हुकूमत से, निगरां वजीर आजम से, निगरां वजीर आला से, रियासत से, मुमलिकत से छलकने मत दीजिएगा। इसमें तेजाब भरा हुआ है, इसमें बारूद भरा हुआ है, इसमें आग भरी हुई है। अब किसी और ने किया तो इस शहर के अमन की सारी जिम्मेदारी उन पे होगी। मैं हुकूमत से, निगरां वजीर आजम से, निगरां वजीर आला से, रियासत से, मुमलिकत से सबको ये दरख्वास्त भी करता हूँ, मुतनब्बे भी करता हूँ कि जितना बर्दाश्त कर सकते थे वो कर लिया है। ये 3 जनाजे उठाने के लिए हमने ये जद्दोजहद और ये अमन का पैगाम फैलाना नहीं शुरू किया था। सबको इल्म हो, तारीख गवाह है तारीख गवाह है। आज मैं बड़ी जिम्मेदारी से यहाँ पर पूरी MQM की क़यादत मौजूद है। मैं बड़े यकीन के साथ पूरे पाकिस्तान को यकीन दिलाना चाहता हूँ कि हम लड़ना नहीं चाहते, लेकिन तारीख गवाह है, पाकिस्तान गवाह है, इस शहर की सड़कें गवाह है कि हम लड़ना जानते हैं, हम लड़ना चाहते नहीं हैं। आप हम पे जंग मुसल्लत ना करें, और जो कुछ पाकिस्तान के आइन में है, जो कुछ कुरान में है, वो वाला इंसाफ चाहिए। जान के बदले जान चाहिए। अदालतों के चक्कर मत लगवाइएगा, हमें तारीखें मत गुजरने दीजिएगा। फौरी इंसाफ होना चाहिए, और वो इंसाफ जो होता हुआ नजर आए। इस शहर का हमने बड़ी मेहनतों से, बड़ी मशक्कतों से, बड़ी कुर्बानियों से ये शहर अपने असल की जानिब लौट रहा है। इसकी रातें जागने और दिन आबाद होना शुरू हुए हैं, इसके मज़ाफ़ात रोशन होना शुरू हुए हैं। उम्मीद की किरण अब शोलाए आतिश न बनाइए, उसको यकीन को बढ़ने दीजिए। ये नुकसान याद कीजिएगा, याद रखिएगा, ये हमसे बड़ा आपका नुकसान ना बन जाए। मत हमें धकेलें आपकी जानिब, ना हमारे खिलाफ ऐलान जंग करें। जिसने भी किया है, जनाब जरदारी साहब, इन लोगों के हाथ में दस्ताने उतरे हैं तो पता ये लगा है कि इनका ताल्लुक पाकिस्तान पीपुल्स पार्टी से है। हमसे आपकी कोई दुश्मनी नहीं जनाब। अगर आप दुश्मनी का आगाज कर रहे हैं या आपके इल्म में नहीं है, और आपके लोग या आपकी मुकामी क़यादत इस तरफ धकेलना चाहती है, ये सियासत आनी जानी है, ये हुकूमतें आनी जानी है। इसको जिंदगी और मौत का मसला न बनाएं। आपके पास हथियार है, हमें पता है। आप इस शहर को बैरूत बना सकते हैं, MQM के होते हुए बेगैरत नहीं बना सकते। बहुत बहुत शुक्रिया। कोई
थैंक यू। सही है।
कराची में MQM पाकिस्तान के रहनुमाओं की मीडिया से गुफ्तगू जारी थी। खालिद मकबूल सिद्दीकी का कहना था कि मैं निगरान सूबाई हुकूमत और रियासत से दरख्वास्त करता हूं और मुतनब्बे भी करता हूं कि जितना बर्दाश्त कर सकते थे किया, वो इंसाफ चाहिए जो होता हुआ नजर आए।
इस्लामाबाद हाई कोर्ट ने हल्का NA 35 को हाट की हल्का बंदी के खिलाफ दरख्वास्त पर फैसला महफूज कर लिया है। हुसैन अहमद चौधरी से मजीद जानेंगे। हुसैन, बताएगा फैसला कब सुनाया जाएगा?
जी देखिए, NA 35 स्क्वाड से मुतालिक ये हल्का बंदियों का ये केस था। इस्लामाबाद हाई कोर्ट के चीफ जस्टिस आमिर फारूक ने समाअत की है। दरख्वास्त गुजार का कहना था कि इलेक्शन कमीशन ने कुछ हल्के बड़े कर दिए और कुछ हल्के छोटे कर दिए। कुछ हल्के जो है वो 6 लाख आबादी मुश्तमिल है और कुछ हल्के जो है वो 13 लाख पर हैं। चीफ जस्टिस ने कहा कि बादी नजर में दरख्वास्त गुजार का मौकफ कानूनी तौर पर मजबूत है, मगर इलेक्शन कमीशन का मौकफ जमीनी हकायक के मुताबिक है। चीफ जस्टिस ने आम रिमार्क्स देते हुए कहा कि अगर हम सेक्शन 20 के तहत चलें और तमाम हल्कों की आबादी के बराबर करें तो फिर पूरे मुल्क में नई हल्का बंदी करनी पड़ेगी। चीफ जस्टिस ने कहा कि नई हल्का बंदियों से इंतखाबात में ताखीर हो सकती है, जिस पर कुछ लोग खुश होंगे, जिसके बाद अदालत ने दलाइल सुनने के बाद फैसला महफूज कर दिया है। जी
ठीक है, बहुत शुक्रिया हुसैन अहमद चौधरी।
आजाद कश्मीर की कानून साज असेंबली ने भारतीय सुप्रीम कोर्ट के फैसले के खिलाफ मुज़म्मती करारदाद मुत्तफ़िका तौर पर मंजूर कर ली है। करारदाद में कहा गया है कि भारतीय सुप्रीम कोर्ट ने इंतहा पसंद मोदी सरकार का 5 अगस्त 2019 का फैसला बरकरार रखा। सुप्रीम कोर्ट ने मोदी हुकूमत के ख्वाहिश के ऐन मुताबिक फैसला दिया है। फैसला अक़वाम मुत्तहिदा की करारदादों के मुनाफी है। भारतीय सुप्रीम कोर्ट मोदी को कोर्ट में तब्दील हो चुकी है। कश्मीरी अपनी आज़ादी के लिए जद्दोजहद जारी रखेंगे।
ARY न्यूज स्टूडियो से फिलहाल इतना ही।
मजीद खबरों और तफसीलात के लिए आप देखते रहिए ARY न्यूज।
नया सनसिल्क थिक एंड लॉन्ग, इसमें है योगर्ट प्रोटीन और केराटिन का सुपर मिक्स, जिससे बाल दिखे 2 गुना ज्यादा घने और मुमकिन करे हर हेयर स्टाइल।
कैसा लगा हमारा स्टाइल?
इस शादी सीजन जब बाल हो थे, कोई भी स्टाइल करो पिक। हाय गर्ल्स, I love going out, लेकिन ये आउटिंग्स कर देती हैं मेरी स्किन को डल, छुप जाता है मेरा ग्लो। इसलिए मैं यूज करती हूँ पाम ऑयल नेचुरल्स, मिल्क और रोज पेटल्स एक्सट्रैक्ट से बना, मेरी स्किन को बनाए सॉफ्ट एंड ग्लोइंग। पाम ऑयल नेचुरल्स, यू कैन फील इट।
हमारे यहाँ हर इंसान में एक अच्छाई बसती है। ये अच्छाई तो है जो जिंदगी को बेहतर बनाती। जो भरोसे के डब्बों में बंद की जाती और सजा के सामने रख दी जाती। नेस्ले, अच्छाई से बना अच्छाई के लिए।
अस्सलाम वालेकुम एंड गुड इवनिंग। मैं हूं मेहर बुखारी। हमारी सियासी तारीख में मां सवाए जमात इस्लामी के कौन सी ऐसी जमात है कि जिसने जमहूरी असूलों पर इंट्रा पार्टी इंतखाबात करवाए हों, लेकिन कमीशन में रजिस्टर्ड 174 सियासी पार्टियों के इंतखाबात के कहीं शवाहिद नहीं कि जिन पार्टियों ने पार्टी इंतखाबात के नतायज से इलेक्शन कमीशन को आगाह किया हो और जिन्हें तस्दीक का शर्त भी बख्श दिया गया हो, उनके इंतखाबात कितने जमहूरी और नुमाइंदा होते हैं। ये सवाल आज हर उस सियासी जमात से है कि जिसे इस वक्त पीटीआई के इंट्रा पार्टी इंतखाबात पर जमहूरियत याद आ रही है। पाकिस्तान पीपल्स पार्टी, पाकिस्तान मुस्लिम लीग नून, JUI फे, ANP और दीगर सियासी जमातें अपने बानियों, घरानों, शख्सियात और ग्रोहों की सूरत जिंदा हैं। उनका जमहूरी अमल से दूर दूर तक कोई वास्ता नहीं है। सियासी पार्टियों में खानदानी बादशाहत के अलावा पार्टी का कोई वफादार और काबिल रहनुमा इसलिए मरकजी हैसियत हासिल नहीं कर पाता कि उसका बादशाह या बादशाही खानदान या शाही खानदान से कोई ताल्लुक नहीं होता। जमहूरियत की दाई पाकिस्तान पीपल्स पार्टी, जिसे जुल्फिकार अली भुट्टो ने मुनज़्ज़म किया, इस जमात में आज तक कोई मुतबादिल क़यादत उभर ना पाई और ये खानदानी विरासत की लपेट में आ गई। मोहतरमा शहीद अल्लाह उन्हें जन्नत नसीब करे। उनकी शहादत के बाद एक वसीयतनुमा कागज के टुकड़े पर आसिफ अली जरदारी ने जमहूरियत के सारे असूल कुर्बान कर दिए और पार्टी को अपनी मुट्ठी में ले लिया। और अब चेयरमैन आसिफ अली जरदारी और उनके बेटे पार्टी के शरीक चेयरमैन हैं। जरदारी साहब अपने बेटे को पार्टी चेयरमैन का ओहदा इसलिए नहीं थमा रहे कि वो अभी तक बकौल उनके सियासी तौर पर नाबालिग हैं। अगर पीपल्स पार्टी जमहूरी जमात है तो फिर कोई गिलानी, कोई मियां, कोई बट्टू, कोई राजा इस पार्टी का चेयरमैन क्यों नहीं? इसी तरह मुस्लिम लीग नून के 4 बड़े ओहदे शरीफ खानदान के पास हैं। बड़े भाई नवाज शरीफ पार्टी कायद, छोटे भाई शहबाज शरीफ पार्टी कायद, बेटी मरियम नवाज सीनियर सदर, नायब सदर और चीफ ऑर्गेनाइजर और समधी इसाक डार साहब सेक्रेटरी खजाना हैं। गोया नून लीग फैमिली लिमिटेड कंपनी दिखाई देती है। इस कंपनी में भी पहले बरसों इंतखाबात होते नहीं, दिखते नहीं, बार बार अल्टीमेटम्स दिए जाते हैं और अगर हो जाएं तो बिला मुकाबला इंतखाब का एक गैर जमहूरी अमल जमहूरी लिबादे में खूबसूरती से पेश कर दिया जाता है। बड़े ऐसन अंदाज में अंजाम को पहुंच जाता है। 2009 और 2010 में जब मियां नवाज शरीफ को नाअहली खत्म किए जाने के बाद पार्टी सदर मुंतखब किया गया तो उस वक्त स्टेज पर जावेद हाशमी भी मौजूद थे। इजलास में एक मौका ऐसा भी आया नाजरीन कि तमाम पार्टी कारकुनान खड़े हो गए और उन्होंने हाशमी हाशमी के नारे लगाना शुरू कर दिए और हालात के तेवर भांपते हुए या बदलते हालात को देखते हुए शहबाज शरीफ साहब डाइस पर आ गए और उन्होंने जावेद हाशमी को पार्टी का सीनियर नायब सदर नामजद करने के लिए कारकुनान से राय ली। नेचुरली जावेद हाशमी सीनियर नायब सदर मुंतखब हो गए, मगर मियां नवाज शरीफ जावेद हाशमी की असूली सियासत से जरा नाला दिखाई दिए। जावेद हाशमी जब सीनियर नायब सदर मुंतखब हो गए तो उन्होंने मियां नवाज शरीफ को मुखातिब करके कहा था कि मियां साहब मैं ऐसी गुस्ताखियां करता रहूंगा। और फिर आज तहरीक इंसाफ को जमहूरियत का दर्ज देने वाली मुस्लिम लीग नून का अपना हाल यह है कि इस जमात के अपने इंट्रा पार्टी इलेक्शन 22 मार्च 2022 को होना थे। रिकॉर्ड कर लीजिए, मार्च 2022 को होना थे, मगर पार्टी ने इलेक्शन कमीशन को दरख्वास्त देकर ये इलेक्शन 14 मई 2022 तक मुलतवी करवा दिए। ये तारीख भी गुजर गई। कानून के मुताबिक मुस्लिम लीग नून को 21 मई 2022 तक इलेक्शन कमीशन को सर्टिफिकेट जमा कराना जरूरी था, लेकिन 22 तारीख को इलेक्शन कमीशन ने शहबाज शरीफ साहब को नोटिस जारी कर दिया और वार्निंग दी, मुतनब्बे किया कि अगर इंट्रा पार्टी इंतखाबात ना होए तो पार्टी को इंतखाबी निशान अलॉट नहीं किया जाएगा। और बाद अज़ां पार्टी कायद और पार्टी के जनरल सेक्रेटरी को भी हतमी शोकॉज नोटिस जारी हुआ। मुस्लिम लीग नून ने इलेक्शन कमीशन को यह यकीन दहानी करवाई कि साल 2022 के आखिर तक हम इंट्रा पार्टी इंतखाबात हर सूरत करा लेंगे। साल का यह आखिर भी गुजर गया। 5 जनवरी 2023 को इलेक्शन कमीशन ने एक अल्टीमेटम और दिया, 1 हफ्ते के अंदर अंदर इंट्रा पार्टी इलेक्शन करा लीजिए या इंतखाबी निशान से महरूम हो जाइए, तैयार हो जाइए इसके लिए। इलेक्शन फिर भी ना होए। इसके बाद इलेक्शन कमीशन ने एक और आखिरी मौका देते हुए 2 माह की मोहलत फराम कर दी। 14 मार्च को ये 2 माह भी गुजर गए। इलेक्शन कमीशन ने केस उठाया मगर पुरस्रार तौर पर इसे कॉज लिस्ट से खारिज कर दिया गया। इलेक्शन कमीशन की जानिब से बार बार मोहलत के बाद बिलाखिर 16 जून 2023 को मुस्लिम लीग नून ने इंट्रा पार्टी इलेक्शन कराया।